Adjournment, from the imputing order, the entire fishery will be fished out, my lord.
Entire fishery.
Yeah, this is a fishery cooperative society, my lord.
What is the urgency?
Yeah, there is the, my lord, that because the imputing order has been passed in favor of the respondent number 5.
What is that order?
Respondent number 5, my lord.
What order?
Imputing order, my lord. His membership has been retained, my lord, in the society, and also RDR dissolved committee has been restored, my lord. There is the thing, my lord. Tomorrow, my lord.
Tomorrow. Have you filed it?
Yes, sir. Yes, all 20. Yesterday I have filed one. Serial number also I have got it, man. All right.
All right. To the lord. Malad, it's an eviction matter. So Malad, an 18-2 notice has been given. Today the reference on 18-2 will be decided by the division bench. Malad, judgment will be given. Here there is a tenancy, Malad, and somehow government has come up with the 18-2 notice with a 15 days time, which is an 18-3. Absolute illegality, Malad. We are there having shops for last 30 years, Malad.
No, but you said division bench is...
He's giving judgment today, Malad, on 18-2. That is a reference why 18-2 needs a required notice or not. Whether there is an adjudication of that 18-2. Is giving judgment at 2 p.m.
Then?
Malad, this is an eviction, but can it be listed tomorrow, man?
No, what is the connection?
Connection, Malad, because notice was given to me on 18-2 for eviction.
So let us await for the judgment.
Judgment, Malad, is a different issue, Malad, is a reference. Malad,
I know it is a reference, but with regard to 18-2.
18-2, Malad, because...
whether it is necessary to give a notice or not.
Malad, if by chance if it is not listed, Malad, then Malad, I will be no here, Malad.
You make a mention tomorrow, but let the order be placed before the court first.
Malad,
isn't it?
Eviction matter, Malad, because otherwise I will be absolutely, all the shops will be evicted, Malad. I will place the judgment tomorrow, Malad. If it goes against me, then I have nothing to say, Malad. Only can it be listed, Malad. Your lordship will look into it. There is a civil suit, there is an injunction given. Still, then, Malad, there is a notice for it.
All right.
What?
I beg to mention item number 7, Lordship. I want to withdraw this petition, Lordship.
Withdraw?
Yes, Lordship.
You want to withdraw?
Yes, Lordship. With the liberty to avail appropriate remedy under the law.
Your name?
J. Singho, Lordship.
J. Singho, Actually, like to withdraw the petition. Where paid is allowed, yes.
I am for 1 to 5, Lord. May I please, Lordship? With the consent of other side, Lordship, I beg to mention item number 30 and 31.
30,
30 and 31. Similar matter is coming on 24/7, Lordship. I have taken the consent, Lordship. Let it become on 24/7.
30 and 41.
31.
31.
Yes, sir.
Sorry, 30 and 31.
Yes.
Okay, and
let it come up on 24/7, Lordship. Similar matter.
You have taken consent?
Yes, yes, Lord.
Mr. S.S. Roy, CCC, appearing for the respondent, submits that 6 matters are registered on 24.
24/7.
07. 2024. These 2 matters, 30 and 31, listed on 24/7, along with
arbitration petition 10 of 2024.
Arbitration petition 10 of 2024.
Okay.
You submitted consent of the petitioner in person has also been made. This recording. Yes.
Okay.
May it please, Your Lordship. I want to pray for listing of a writ petition, if possible, tomorrow, Miller.
What
difficulty is the circle officer, the revenue circle, Miller, had issued a notice entering in acting as a civil court, Miller. He is telling me, as per your sale agreement, pay up the money or we'll forfeit and take action against you. We appeared, but he's not budging, Miller. Verbally, he's doing that. Now, since the vacations are ensuing, coercive actions he's taken, I have to challenge that again back. So tomorrow, Miller, I'm praying for that consideration.
No, has he passed an order?
He has not passed an order. He is bullying out, Miller.
Then?
That's what is happening. We have appeared. We are represented to the council. Now he is saying you pay
Why
up.
are you apprehending if he is not passed an order?
That is what has been told to us. He is not writing it, Miller. Since the vacations are ensuing, just to that action. Let the proceeding continue. No stay. Let the proceeding continue. No coercive action. Just be fair on whatever notice you give.
Coercive action is a stay.
No. I'm not on that. Let him proceed with that and come to a logical end. But whatever he is submitting,
what is the idea of filing a preemptive writ petition.
It is not at all a preemptive writ petition, my lord. We did not come earlier. We approached there. We said, kindly give us a complaint, kindly give what is it. We'll comply. We are appearing.
Let him pass an order, then
My
you come
lordships,
before the court.
since the ensuing vacation is there,
So-
in terms of that, I'm praying for a consideration only. If I'm able to satisfy your lordship,
Consideration of what in a case where there is no order passed.
my lord, this is a case where a circle officer has usurped the jurisdiction and entering into a negotiation with us to pay up, others will take action against you. That's the case, my
We'll
lord.
see.
Obliged, lordship.
May I please, your lord? My lord, I beg to mention regarding item number 8, my lord, that the aggregate eviction matter, my lord.
Yes.
We have filed an additional affidavit that may kindly be called for, my lord. And secondly, a similar,
When did you file it?
my lord, filed it today, my
Then?
lord. My lord, and the writ petition, similar petition has been filed, my lord, in connection with item number 8, my lord. It is filed today, my lord. My lord, can it be both the petitions be taken up at 2 p.m., my lord?
No, no.
My lord, some urgency is
No,
there
no, no,
even,
no.
even after the, my
You
lord,
file it today.
today,
You
my lord.
file an additional affidavit today, and
No,
you
no,
want it at 2 p.m.
No, my lord, the, that additional affidavit is, can be called for, but a fresh writ petition has been filed, my
You
lord.
will have it tomorrow. Give the list, both the matters. Item number 8,
But my lord, there is an interim order operating till today, my lord.
we can't help it. Let it be tomorrow. Then you should have filed it earlier. Why have you
My
filed
lord,
it today?
is, my lord, lots of document is required to be prepared. I have tried my best.
Can't help it.
Then both. the-
Either you make either you see,
My lord,
vacations are there at the request of the
that-
bar,
I can understand.
isn't it?
My lord,
So therefore, you know that there is a vacation ensuing,
my lord.
and you wait to file these
No,
affidavit
no, my
today.
lord, actually what has happened, my lord, the documents which we have been furnished, my lord, it is the, even after my lordship stay order, my lord, they have evicted. My lord,
This matter, item number 8, we can see, all right. We'll take it up. It is already listed. The other
Fine.
matter, we don't know.
then can be tomorrow, my lord.
Yes, tomorrow.
Fine. Obliged.
May it please your lordship. So with the consent of other side, I beg to mention for item 37, so maybe adjourn for today and may come after
Item 37, the
37.
request of respondent.
respondent number 5.
Respondent 5 submits that with the consent of the counsel for the petitioner, the matter be listed the month of July, third week of July. Matter be listed accordingly and on a date to be fixed by the registry.
May it please the Lordship. With the consent of other side, I'd like to mention item number 21, Lordship.
21,
Yes, Lordship.
yes.
Lordship may take up the matter after vacation. Lordship.
Item 21 to be listed after 3 weeks at the request of counsel for the
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 5. Honor, the affidavit in opposition has been filed by the respondent in this case yesterday itself. So the same is also not on record. Let the matter be listed soon after the vacation.
Item 5 will be listed after vacation at the request of the counsel. The writ petitioner.
Yes.
Mr. Paridi.
Much of.
May I please your lordship? Lordship, I beg to mention for listing of the
But
matter.
have you informed the other side?
Yes,
You have taken consent.
yes,
Consent of counsel for the respondent. Yes.
much of.
May I please your lordship? Your lordship, I beg to mention for listing of the matter on tomorrow, your lordship.
What is the matter?
Your
What
lordship,
urgency?
it is the land matter that the police is interfering in the land rights without any order from the court, your lordship, and they have diverted me from my property and they have occupied the property, your lordship.
How police has occupied your property.
Yeah, police with the help of the land grabber, your lordship.
You go and file a case under the Land Grabbing Act. You go there and file.
Your lordship, it is to be hard because the police along with the land grabbers, they have.
That's
occupied,
right.
your
There is an
lordship.
act called the Land Grabbing Act. There is a forum already established. So you should go and approach that court.
Your lordship, it is a writ petition matter, your lordship. So
Writ petition matter, I know, but you have an alternative remedy. Have you filed the petition?
yeah, yes, lordship.
When?
April, your lordship.
You
the
filed
month
it
of
in April.
Yes, lord.
Why is the
It
matter?
was an objection, your lordship, so we had rectified it, your lordship.
Silo. Verify. Yes, okay. Subject to verification. Clearance of your defects.
Yes, lordship.
Yes.
Much obliged, your lordship.
Yes.
Lordship, that's why I mentioned for listing of the WPC, lordship.
Why?
Tomorrow.
Why?
Urgency is there.
What is the urgency?
Lordship, in this matter, we have not recovered the security money, lordship.
There is no urgency there. Let it come on its own. contract matter.
Yes, yeah,
It come on its own. No urgency. Yes.
My lord, one IA has been filed, my lord, Lordship will find IA number, my lord, 1979/2024.
Yes.
For impleading party respondent number 9. My lord, in view of the, my lord, notification, Lordship will find at page 9. Page 9 of the IA,
Page 9.
page 9 of the IA 1979.
IA is 1521.
No, that is different IA, my lord. IA 1979. Item 51, my lord. I'm sorry, my lord. Item 51 in the supply. It is taxed with the, my lord, item 1. Item 51.
আপনি না জানেন প্রিন্সিপাল সেক্রেটারি নেই করা হবে
Page 9, Lordship will find.
Yes.
My lord, last paragraph, my lord. The statutory powers and administrative powers as exercised by the divisional commissioner at present will henceforth be exercised by the commissioner and secretary, stroke principal secretary of the general administration department. Now, the principal secretary general administration department should be made party respondent number 9. Otherwise, my lord, the appeal pending before the
No, Lordship, after this notification was issued, the special secretary.
You are agreed by what?
my lord, we are agreed by the, my lord, award,
They have,
my lord, given by the, my lord,
So
law authority.
there is a provision
Yes.
There is a
for
provision.
the arbitrator.
Yes, appeal has been filed before the, my lord, that authority, my lord.
Is it an appeal or an arbitrator?
No, arbitrator is appointed as
Ah,
special secretary to
Special
the
secretary.
government of Assam.
Now, he is the, my lord, secretary general administration is the, my lord, competent authority. As per this
No.
notification,
Appeal filed
Nothing happened.
under what? Under what provision?
my lord.
You have filed an appeal under which provision?
My lord, under section 3G5,
3G5, no?
3G5 of the National Highest Act.
Resettlement.
এটা তো লোক হবে না তো। এটা দিদি আছে আনিস না।
Resettlement.
হয়তো করতে না পারে।
3G5, my lord.
এটা নাই নি। লাগাই দিল।
And I am sorry, my lord, I have marked the, my lord, certain portion.
3G. So
3G5.
3G5.
Well.
Is to be the arbitrator.
The arbitrator.
Then why you say appeal?
Now, earlier, yes, application.
Application.
Yes,
the arbitrator.
application we have already filed.
Ah,
Now, as per this notification, my lord, the principal secretary is to call on the, my lord, side application.
No, it is the special secretary.
Yes, special secretary to the government of
It is the
Assam.
special secretary as per his
As per this notification,
Notification ওলাইছে।
the
21st February.
divisional commissioner was never given the power.
Yes.
earlier divisional commissioner was the, my lord,
No.
Earlier,
You have
earlier.
this notification.
এখন নাই এখন
First of
ওলাইছে।
February 2024.
Let them approach before the
It is before the special secretary.
then we have to make.
approach.
I don't know what you have to make, but a divisional commissioner, commissioner and principal secretary is not a necessary part.
Special secretary. my lord.
We don't know. It is for you to apprise yourself. There is a notification here.
Well.
Specifically empowers special secretary to government of Assam as the arbitrator.
Let
Here is
them
the-
approach.
You give him a copy.
I have. Hello, look at the more আছে।
Yes, I'll make my lord.
Let them oppose the, before the,
No, but why do you want to make them a party? You have to go and approach that
Yes.
authority.
Unless my lord he is made party, my lord, already my lord application has been filed before the my lord principal secretary.
All right.
Yeah,
Then you withdraw this IA.
Yes, my lord,
IA so and so 1979 is not pressed by the petitioner at this stage at the same. Yes. Then
then my lord, liberty may be given my lord, to make party respondent of the special
you
secretary.
have the liberty,
eh,
you can make anybody a
Yes.
party. No
let
liberty.
them
I'll
appoint
file
the
it.
special secretary.
That will be listed after 4 weeks.
No, what happened, Lordship, they are getting the interim order.
What interim order?
Yes, Lordship, kindly go to the interim order. They unnecessary, they are harassing us. We cannot go
Where
ahead
is
with
the
our
interim order?
construction work. Interim order.
Interim order is not to demolish the my lord building unless the
Already,
award is paid.
already 3G award has been declared, Lordship.
Now 3G award has been declared and
Yes,
that
after
my lord,
that-
application has been filed before
My
the.
interim order should continue, Lordship. Already
You have
3G,
filed your application.
Application has been filed
And then
before the
you
principal
are aggrieved by the quantum, isn't it?
quantum.
You have received a certain amount of,
Not yet received, my lord. Only
No.
award has been declared.
that's right.
3G award.
There is a finding here where it says that you have received some amount.
No, my lord, no amount has been paid.
You can-
Not a single amount.
Who is required to pay that amount?
The my lord, Kala competent authority.
Who appears for Kala? What is the status?
We have received the instructions. The estimated amount of rupees 84,26,548 only has been forwarded to the General Manager PMU, Bongaigaon NHS DCL, while later dated so and so for submission of the draft 3G award to this office. Once the draft 3G award received from NHI DCL, these instructions we have received in the month of March. Thereafter, they have filed their affidavit.
We have
In-
filed an additional affidavit.
No, but has he been paid the amount?
We have deposited the amount.
Before whom?
To the Kala. Lordship.
Lordship, may I get a copy of this affidavit so that I can verify and place the same before you?
You are entitled to a copy. You don't have to-
Lordship, the copy was not
Why
served upon us.
don't you serve copies? It's matter of, it's specified in the rules.
It will be, okay.
You are required to serve copies on all councils.
That is why, Lordship. In that
Let
case,
it come
Lordship,
after 4 weeks. You decide amongst yourself who is to pay the amount.
Lordship, we have already deposited.
You
but
have deposited, he has not received.
Lordship, if it is deposited, if I get the copy, in that
Yes.
case, I can verify and get
Released
the.
after 4 weeks. Respondents will apprise the court with regard to the release of compensation to the writ petitioner.
Respondents may continue with their work. Lordship. Respondents, the
You
elected.
continue provided the amount is there. You have acquired the land. The man has not got it.
No, Sabonara, copy ka jo mo pathai pala instruction.
Interim order may continue. my lord.
The matter be listed on 15th of July.
Lordship.
Interim order will continue. Further extension will be reconsidered on 15th of July.
Oblige.
দিয়া নাই নেকি?
নাই দিয়ে নিদিলে মই কেনেকে ইনষ্ট্ৰাকশ্যন পাম গমে নাপাওঁ কি হয়।
The lordship is the order, last order. my lord.
Yes, any instruction?
Lordship, I have communicated and received telephonic instruction that bamboo fencing is erected on government land, not on the petitioner's land and disputed land, Lordship. I have not received written instruction, Lordship. Telephonic instruction.
All right, let them get their instruction.
Instruction, my lord, only thing is that already they have enjoyed one portion of that.
This is a contempt matter.
No, that is there, my your
What is the
lordship.
status of, what is the status?
Especially order was there, my lord.
What is the status of the writ petition?
Hello?
What has happened to the writ petition?
No, it is pending, my lord. They have submitted the reply also. They are very much aware of the order
So
also.
let this matter be listed along with the writ petition.
So that can be done only in the meantime, my lord, let them say, my lord, so that the court order may to violate.
You get your File your affidavit immediately.
Lordship, a notice not received. This is contempt matter, Lordship. Notice had to go to.
Your lordship directed us to give a copy that was given to them.
All right. Third learned
Lord-
city council. Chair Chaudhary, assisted by Mr. Cormier and MS Purva. Oh, you are not appearing. Otherwise,
I am not, Wakalatnama have to be
issue
given.
notice on the respondent. The contempt petition is filed stating willful disobedience of the order dated. Which order?
25, page 12. 25/7/27. 23.
5/7/2023, passed in the PPC number 4171 of 2023. So, it is submitted that though the order of the court, though the writ petition will be pending, there is a specific direction the respondent authorities, namely respondents 2, 3, and 6, who are presently respondents 1, 2, and 3.
Yes.
The writ petition not to interfere and disturb the possession of the petitioner in respect of land covered by DAC number 205 and 206, included in periodic pattas number 105 and 132 of Bozar, data number 22 near Doboka, Nogam Road, under Junamu Muda, Doboka Revenue Circle, as well as the building standing there till the next returnable date. Stop. Counsel for the petitioner submit that the interim order still subsists, and an affidavit has also been filed by the writ petitioner,
By the respondent.
by the
Government.
respondent,
Yeah.
stating that no eviction is
Deputy.
carried out in any PP land of the writ petitioner. Stop. However, petitioner is before this court saying that they have erected a bamboo fence,
Yeah, paragraph 10 of my, madam.
bamboo fence
Page
there
7.
on their land, and there is imminent threat of encroachment of the land and causing damage to the building standing there. Therefore, contempt order has been filed as there is a steps of the respondent by registered post AD along with reports will begin within 1
Days,
week.
madam? 2 days.
Within 1 week from this report.
Obliged.
Yes, affidavit, Mr. Sharma,
They have filed their affidavit.
they filed.
They have filed their affidavit. Lordship, in the page 28 of their reply, they stated, they have admitted that no.
There is no affidavit here. WPC 1932.
190.
There is no affidavit here.
I have received a copy of.
You may have, but it is not here. Learned counsel for the petitioner submits that an affidavit has been filed with the respondents. However, a copy of the said affidavit is not connected to the writ petition. Therefore, registry is directed to this matter. Again on 15th of July, by which date the affidavit stated to have been filed by the respondent will be connected to the writ.
Okay.
Ma'am, I need some time. I have to take some instruction from my father.
The learned counsel petitioner wait for some time to complete the matter. Mr. H. Sharma, an advocate, represent the respondent number.
Hari number to need.
Sorry, no, bro.
That GDAT amount has already been released to the petitioners, Lord.
3,
One has been.
4. MSG Adoriga for number 1, MS Arbora for 5. Matter be listed after 4 weeks. After 4 weeks.
Please, Lordship. Lordship, on the 3rd of June, Lordship, this matter came up for motion. I had submitted before your Lordship that my business was closed, so notices were not served upon me. Consequently, this court ordered the respondents to produce the record, Lordship. Subsequent to that, they were not able to produce. Today, I suppose they have the records.
Record says that the address which was provided with the petitioner notice was sent. The total endorsement is that the address is left.
Huh?
Address is left.
Left.
As many as 5 notices were sent.
Since my business was closed down, Lordship.
And Lordship, they are choosing the same address in the writ petition also.
So, Lordship, since the notices were not served, which was my case, I am just wanting one chance so that I can produce relevant documents.
It was served in the address.
No,
It
it
will be served.
returned back, Lordship.
No, it returned back because you were not there.
Lordship, my business closed down. That is my pleaded case.
No, where's the question of your business closed does not mean your tax liability will also be closed.
No. Tax
Then-
liability, I will contest. I will
then-
pay, Lordship.
then-
Whatever is payable, I will pay. My only contention is, Lordship, I was not afforded with the reasonable opportunity
You
of
have,
being
you have,
heard.
you have given the address which is marked here.
Lordship.
Then
Lordship, business
in the
closed
writ
down.
petition itself.
Subsequently, they never got an opportunity to change their address. So I have to give the address whatsoever was there at the time of registration.
So therefore, if you say this is the address, any document served at the correct address is deemed to be served.
Lordship, if
That's the law.
if I may be allowed to submit, Lordship, there are two matters which need to be considered, Lordship.
Yes.
My first submission will be that since notice was not given to me, even if for my fault, if I was deprived for contesting my case, Lordship, since I have all the invoices which I have enclosed with this writ petition from page 18 to page 38, Lordship.
That is already rejected in view of there are so many judgments of the appellate.
Non-submission of invoices because I could not get the notice, Lordship.
Hmm.
That is the first aspect of the case, Lordship.
No, you cannot, your claim that notice was not served cannot be accepted in view of the fact that the notice was addressed to the correct address, which is also reflected in the writ petition.
If your Lordship holds so, Lordship, that is the first aspect of the case.
Right.
Now, subsequently, as your Lordship has rightly held so, I wanted to exercise my right of appeal, Lordship. So when I tried to file an appeal, the system showed some error which is apparent at page para 17 and 18 of my writ petition, Lordship.
Yes.
If I may please read, Lordship. The petitioner begs to submit that thereafter they had appointed a consultant for doing needful to contest the impugned order by filing an appeal. But their consultant informed them that the GST portal is not accepting the appeal of the petitioner, as the appeal can only be filed after complete payment of taxes as calculated in table 15A. And the petitioner was shown a message to make the payment of balance dues and try again to file an appeal. The consultant also informed the GST portal does not allow
You are
the
reading from which page?
Lordship, para 17, page 10.
Yes.
The consultant also informed the GST portal does not allow the petitioner to pay pre-deposit of so and so rupees as outstanding return liabilities were pending with a request to pay off the said dues first. Upon searching of data, petitioner came to know that return related liabilities of 7 lakhs were pending under CGST Act and SGST Act, and a sum of 7 lakhs was available in the cash ledger of the petitioner for payment of such dues. But as the petitioner is not in a position to pay off the old dues at once, the GST portal does not allow the petitioner to make payment of pre-deposit of so and so rupees to exercise their right of appeal in the matter. Subsequently, Lordship, paragraph 18 will also be relevant.
What is your submission now?
Lordship, since I could not even file the appeal because the portal deprives me. Lordship, what happens that the GST Act came into play in 1st of July 2017. I filed returns for 3 months, Lordship, July, August and September 2017. They said there are some dues relating to those months. Because of that dues, I cannot be deprived of my right to appeal, Lordship. They have all their provisions to recover my
Right to
dues.
appeal is a creature of the statute.
Lordship?
Right to appeal
Yes.
is the creature of the statute.
Yes, Lordship.
So if whatever the statute provides, this is the parameters you have to satisfy before filing an appeal.
Pre-deposit, I am willing to pay, Lordship, but
Yes.
they cannot deprive the right to appeal because of some other dues. That is my case, Lordship. They said that some other dues are pending, so I will not take
You
pre-deposit
challenge
for
the
appeal
provisions.
also.
If it is, you challenge, see, these are the provisions of the statute. For your case, we cannot mold, we
No,
cannot
no, it
interpret
is not
the.
required, Lordship, it does not, it is not required to be molded at all,
Then what-
Lordship.
what-
My
what
only
needs-
pleaded case is, Lordship, I want to exercise my right of appeal. For that, I need to make some pre-deposit, and without any provision debarring me from
That will
payment of,
amount to changing the narrative of the statute.
no, Lordship.
It is, you show us a provision that it is permissible, yet you have been deprived of.
No, Lordship, they have to show a provision that if any return related liabilities is pending, they will not accept pre-deposit.
You
There is
show
no
us
such-
from the, you show us from the provisions of the act. What you are trying to interpret, you
Lordship.
show us from the provisions of the act.
Lordship, section 107 gives me the right to appeal, GST Act, Lordship.
GST. Yes.
Appeals to appellate authority. Any person aggrieved by any decision or order passed under this act by an adjudicating authority may appeal to such appellate authority as may be prescribed within 3 months from the date on which the said decision or order is communicated to such person.
Yes.
Lordship, a proviso, the subsection, after subsection 6, Lordship, there is a proviso. No appeal shall be filed against an order under subsection 3 of, unless, no, Lordship, this is the wrong provision. Lordship, subsection 6B, no appeal shall be filed under subsection 1 unless the appellant has paid a sum equal to 10% of the remaining amount of tax in dispute arising from the said order. So the act only says that I need to pay 10% of the tax, Lordship, which I went to the portal to pay. I have also enclosed the screenshot. What the screenshot of the appellate filing says, Lordship, it will be at page.
What about 6A? 6A?
Whatever tax I admit, I will pay in full, Lordship. That is regarding the impugned order, Lordship, not any other dispute.
You are seeking appeal against what?
I am seeking appeal against the impugned order, which levies a tax of 39 lakhs or like. And my case is, I am not even liable to pay a single penny, Lordship. I have all the invoices in support of the input tax credit claimed by me. So 6B will be applicable. I went to deposit 10%. Without there being any provision as regards any earlier return related liabilities, they are depriving me from my right of appeal, Lordship. This is my only pleaded case, Lordship.
Yes, Mr.
With regard to earlier text, with regard to older text, there are some notification. And at this moment, some notification is not with me. But we may take up day after tomorrow or reopening day. Will place all this document.
In that case, perhaps notice may be issued with the direction of no coercive action.
Heard an account for the parties to notice written about after 2 weeks. Mr. HCKL and appearing for the respondent. The way down the grievance of the writ petitioner is that under section 1076B, petitioner is entitled to file an appeal after payment of 25% of the disputed amount.
10%.
Sorry?
10%.
10%. However, it's submitted that you've been deprived from filing an appeal without clearing the earlier dues, which is not mandated of the statute. The grief is approach this court. Praying for that. Mr. HCL he submits that he has there are certain notifications that he should with demands which provides that earlier dues will have to be cleared before an appeal can be filed. He, however, does not have copies of the notifications available in court let the matter be listed after
Lordship, in the intake
notice on the prayer for inquiry. After 2 weeks, it will come. Let the matter be listed on 22nd. 22nd July. Report to break. Yes. Yes, yes, yes.
Yes, my lord, already my lord, it's a settled matter, what happened, my lord? The petitioners are occupied the common land, my lord. I am not for the settlement, my lord. What happened, my lord? Common land has been occupied by the petitioners and other similar persons since 1976. In the 1999, my lord, one notice was issued by the authority concerned to vacate, directed to vacate the place, my lord. In this regard, my lord, we have first approached the revenue board, and revenue board did not allow our application, my lord, and then we have
You are
approached.
praying for a similar order.
Yes, my lord.
That page number,
Annex R8 lottery. And really,
order dated 27/4.
yes, my lord.
Mr. Pujari,
Application. They are illegal occupants, and otherwise, my lord, what I am submitting, my lord, with regard to my lord, that T-off mini stadium. You know, there were successive litigations filed one after another, and all have been, my lord, eventually, my lord, gone against the petitioners. Now, they may file a representation, my lord, seeking allotment of land. Under the land policy, of course, my lord, the respondents will take a call on it, my lord. But that will not give them ipso facto any right to remain in possession because there is an overwhelming public interest against the private interest.
no, there is an order passed by this court.
So that was, my lord, on the facts and circumstances of those. I am not paying for the settlement, my lord. I may be allowed to file my application before the authority. Since, my
Praying
lord,
for what?
application, my lord, that is at page 47, my lord, starting from 19. Paragraph 19, my lord.
Page number?
47, my lord. 19, 20, and 21, my lord.
No, no, application for what purpose?
What purpose, my lord? This is state, my lord, that considering entire aspect of the matter, I have to file an application with all my documents, writ petition, and
Asking for what?
for consideration. Whether
Consideration of what?
for whether the government can given the settlement to me or not.
Exactly. So settlement, this is a government land. This is a government land.
Purely not only government land, it is a VGR land.
The VGR, then how
VGR land,
settle
my
the
lord,
VGR?
Jagbal Singh is, I am paying only for
Lordship
this,
is well aware of
similar
Jagbal
order,
Singh.
my lord.
You
Supreme
file
Court
your
has,
representation. If it is not disposed of, you come back.
my lord, already
Yes.
other person has filed the.
You
Yes,
file
my
it.
lord. Yes, my lord. This is enough, my lord.
You file it.
Yes. This may be okay.
No, but it is not your case that your representation has been filed, but it has not been considered.
My lord, okay, my lord. That observation I have to given, my
No,
lord.
no observation. This petition, you are seeking a liberty to file a representation.
Yes, ma'am. This is my.
So, do you need a liberty? You can file a representation
My
today
lord.
itself if you want. If that particular representation is not given,
Earlier, other persons have been, other persons already filed their representation before the authority concerned. My lord. That is pending for consideration. And therefore, I am coming before your lordship, similar pair, my lord. We may.
I am asking you why you are asking for that prayer when there is no bar for filing a representation.
Yes, my lord, I will file the representation, my lord. This observation may be like given. No, my lord. This will, my lord, create unnecessary, my lord, because already, my lord, stadium is going on.
We don't like to make rules of the way.
Their rights have not been crystallized.
We'll have to then we'll issue notice and we'll hear the matter. If you want. You want to file a representation, go and file a representation. Why do you want an order of the court, observation of the court? If they don't accept, then you come back. You think about it. Let it come after vacation.
Okay.
Matter be listed immediately after reopening.
I'm so obliged.
By the as the counsel for the petitioner would like to complete the instructions for revenue department.
Revenue department.
You think about it because you don't require a leave from this court.
My lord, I'm coming only that point, my lord. Other persons at that time, my lord, when they have approached your lordship, my
These
lord, at
other
that time, my
persons
lord, I
came.
have
These
not,
other persons came for settlement.
not, my lord, only representation.
No, their writ petition is for settlement.
Yes, my lord. That has
Then
not
the
been
court said
considered.
that okay, you go and file a representation.
Yes.
Now, this is not a precedent in a true sense.
Yes, yes.
There is no finding.
No pending matter.
Therefore, it is not binding.
My lord, because my lord.
Now, if you are asking for settlement in the VGR land, straight away we'll reject it. But if on your own you want to file a representation, you go and file a representation. Who's stopping you? Why do you want an observation from the court? If you file a representation, it is not considered, then you come before the court.
I will take the instruction.
You take instruction.
I'm obliged, no?
Yes.
Non-payment of ex gratia lot.
Ex gratia. Yes, who's appearing for respondent? Respondent, who's appearing?
Revenue.
Revenue.
Same thing.
Karbi Anglong. Anyone for Karbi Anglong?
DC lot. DC.
So we are disposing it of.
My lordship.
DC will verify if the proposal is found, if it is found to be correct, it will be put up before the Secretary Revenue and Disaster Management.
Lord.
And thereafter they will pass appropriate order.
After proper verification, lordship.
All right?
Sure.
Dispose.
Yes, yes, yes.
May please the lordship. Lordship petitioner pertaining to lordship a passport lordship. My lordship petitioner is a lordship working as the life mitra under lordship State Bank of India Life Insurance Corporation lordship. Lordship petitioner applied for having a passport lordship. And one inquiry lordship, the petitioner is found that
There is some case pending against you.
my lord,
No police case.
my lord, already my lord, the petitioners have been granted a bail by the learned bail lordship. I have annexed the order lordship. Kindly see page 21 and
Is there a
extra.
direction? Why are you not giving him the passport?
Yes,
Regarding
lordship.
that, I have to take instruction, your lordship.
Take instructions. Our learned counsel for the part, petitioner is agreed that the respondent number 2, the respondent number 2 has not released, has not granted the passport to the petitioner without any basis. So, MS gave CGC appearing to the respondent submits that she would like to obtain instruction. Therefore, matter be posted after reopening. Learned CGC will obtain instructions in the matter. These extra copies be furnished to the respondent. List again. Up. 22nd July.
Lordship, can it be on the 18 lordship or 19? Because my lord, the authority lordship will be
19.
obliged. lordship.
Obliged, your lord.
Also, kindly possible with the timing.
Lord,
Is it
Korangam
is it-
Goswami, he is in bereavement. We appreciate, my lord. I think they'll be praying for time. My only thing is, my lord, let this come up for motion on the reopening. Till then, no coercive measure.
no,
Let
but
it come.
the issue had already been decided by earlier,
Partly,
already been decided.
yes, by Justice Borua judgment.
Lordship, otherwise, because I have been instructed that Mr. Goswami is going to appear in the matter. The impugned order is of 30th of March. We have not done anything since.
No. But now they have issued.
Interim orders can be considered in
No,
Mr.
no.
Goswami's presence.
They have issued the demand notice.
Lordship may otherwise record my submission that till the next day, your Lordship will not do anything. Interim prayers may be considered in Mr. Goswami's presence, Lord.
No, that I am not objecting, my lord. Let it come up on after vacation. Only thing is, they will not take any coercive measure till that day.
Lordship may record my submission, your Lord. Till that date, your Lordship.
My lord, otherwise the legal position is very clear. My lord, we are dealing in duty paid liquor. Once, my lord, it moves out of the manufacturing bonded warehouse.
These are with regard to what? The ones available with the retailer.
Yes. And they're saying MRP is X, sell in Y. And that is again violative of the statutory prescription.
With effect from the date of the notification
Yes.
or retrospective effect.
They have given retrospective effect. Now, my lord, the consignment or the stock which is in our, possession, these are all duty paid. You can't levy, there is no scheme in the Excise Act.
There's a important point raised,
Yes,
more particularly in view of the vacation.
yes.
It will cause unnecessary hardship to
And in fact, my lord, in one of the litigation, Mr. Goswami had made a submission. He says, Mr. Goswami Lane's Standing Counsel Excise Department categorically submitted that impugned decision will not be will be implemented only in respect of the stocks lying in the warehouse and not the stock which have already reached the retail outlet. Me too.
All right, heard Mr. Kane talk the senior counsel assisted by Mr. And Mr. K. P. Pathak appearing for the respondent.
Respondent numbers 1 to 5, 1 to 5 here.
1 to 5. Mr. B. Gogoi for respondent 6. This petition filed by the petitioner association.
Yes.
Claimed to be retailer of Indian made foreign liquor and are aggrieved by the demand notices issued to their members by the superintendent of excise of Kamrup district.
No, my lord, across the state.
Across the state. Directing the retailers to make payment of ad valorem and VAT on transitional stock.
On the stock lying in there, lying in the premises, your lord.
In our possession, yes.
Lying with the retailers.
Yes.
This these notices, these demand notices have been issued pursuant to the where is the notification?
Yes. Notification is at my lord page 71. Now this is the direction. Room 4.
In
The
pursuant to
retailers,
order dated, what is the date of the notification?
my lord,
33/2024.
33/2024. Whereby additional excise duty and tax arising out of the difference between new and old MRP has to be deposited by the wholesale licensee for the stock in possession. This is for wholesale license.
no, my lord, 4 is regarding retailer. 4.
Whereby the retailers were directed to pay additional excise duty and VAT for the stock under their possession to Treasury Challan / online portal for which demand notice will be issued. Learned senior counsel submits that this order itself reflects that this order will be made effective from 1/4/2020, and there is no scope to implement the same with retrospective effect. He therefore submits that this impugned demand notice contrary to the provisions of the Act and Statutes and calls for due interference by this. He also makes a prayer for adequate. Mr. K.P. Pathak is the copies on behalf of Mr. Boy. He is represent the respondent. Extra copies be furnished. And matter be listed again, tell us.
Immediately on reopening, your lord.
17th, my lord.
17th.
Yes.
17th of July. Issue notice on the interim prayer till the next date fixed. there shall be no course eviction.
Lordship
Yes.
may otherwise record my statement because,
The same thing.
Lordship, because if an interim, that will be in the nature of an
No,
interim.
no,
direction.
till that.
Otherwise,
We are giving it till 17 only.
Yes.
very well.
No course eviction by the respondent in terms of the demand notice issued in pursuance to the impugned
3324.
order dated 3003/2024. Demand notices issued to the members.
Yes.
Of the association. List again on 870.
Lordship is, if you notice on
Interim
the,
order till 70.
My lord, the interim direction will be in respect of annexure G also. Till that day, page
Lordship
75.
may kindly, otherwise say, if an observation is passed that
Page 75
no
also.
coercive steps, no coercive measures will be taken, perhaps that will cover everything, your lord. Because interim periods anyways, your lordship will be considering on the next day.
Oh, yes, that will also do, my lord.
Hmm.
Lordship may say no coercive measure in respect of the impugned order. That will do, my
Otherwise, some of the retailers have already paid, your lordship. They do
Then
not have
what
any.
happens to the sales made in the
Yes,
period?
what has actually happened, your lordship, is they have sold it at a higher MRP, your lordship.
Hmm.
Now, when we are saying that we have sold it at the higher MRP, kindly pay us the balance at
Now,
excise duty.
Mr. Chaudhary, what happens to the sales made?
Yes,
with effect?
that has
No,
already.
lord. Question is, we cannot sell in higher MRP. Regarding fixation of MRP, either a wholesaler or a retailer has got no business, my lord. It is between the excise department and the, my lord, the manufacturer. The moment the stock leaves the, my lord, premises of the manufacturer, there is no excise department has no business to do all these things. My lord, in the name of end of the day, we are lordship will
So essentially, you are saying that this page 75.
is also a demand in respect of the higher MRP. Now they which would like to fix.
So the higher amount MRP will only be applicable to those stock which is not reached your premises.
No, it has already reached. It is in our premises. When we sell, now what had happened, my lord? The MRP is fixed at the stage when the consignment leaves the manufacturer. Supposing a particular bottle costs 400 rupees. Now they have fixed it, say 500. Now we'll have to sell that bottle of where 400 is written at 500 rupees. That itself is an offense under the relevant statute.
So, but if you have sold it,
Yes, they have
then
sold
you are
it at the
required to pay the duty.
higher
No,
MRP.
my lord. Please come to page 75.
Yes.
Kindly see. First one, say existing MRP 400, new MRP is 480. But this new MRP is not, embossed in the bottle. It is something which they have come out with. This is the list.
No, that
Now,
that we understand.
yes,
What we want to say
yes.
is that if you have sold it at 480,
No, we are not selling at 40. We are selling at 400. My consumer will pay a price which is not written in the bottle, Miller.
I will get the records, your lordship.
Yes. In no coercive measure in respect of the impugned actions.
impute demand.
Demands. Deep level.
Mr. Chaudhary, we thought this matter was specifically by you because of something which happened yesterday. It's a consequence of something yesterday. No. Right. And good wishes to the party.
Yes, deep level.
Please, your lordship. I'm challenging the order at page 48, my lord. What happened, my lord, is petitioner husband was registered SSC under GST, my lord. He passed away in 2022, my lord. However, the petitioner could not intimate the department, my lord. In the meantime, order has been passed, my lord. Order has been passed as a dead person, my lord. Death certificate also will find it page 22, my lord.
Order has been passed under this notification.
Yes,
Or-
my lord, but however, order is also time barred because my lord, the last date of issuance of order was 30th of April, my lord. And order is having passed on 4th of May, my lord.
Yes.
22nd, my lord, similar matter.
No, it's no similar, my lord.
Because, my lord, first of all is against the dead person. Second of all, my lord, I'm not challenging the notification, my lord. I'm saying that, my lord, the order has been passed beyond the time limit extended, my lord. Notification is page 47, my lord.
What is the time limit?
Page 47, my lord. 30th of April was there, my lord. Extended time limit, my lord. For the financial year 18-19, my lord. CL number 1, my lord, last.
It has been informed by the council representative for CGST that time was further extended by way of a subsequent
There is no notification beyond this, my lord. I have done so.
And when was the order passed?
My lord, page 48, on 4th of May, my lord. The top, my lord, right side.
Where is that notification, Mr. Gyal? There is a notification
There are extension notifications.
subsequent to this
Yes, sir.
It was the last, my lord.
28th of December.
Yes, sir. In the month of May, some notification. It is issued by the central BST.
Then let us,
There is now I have gone through all notifications, my lord.
he is the standing
lord.
counsel.
My second,
If he says it is there, then
my lord, my
we
lord.
should
No,
give him
my second, my lord, my second argument is that it is against dead person, my lord. Lordship will see, my lord. The order is passed in the name of Satyajit Bordoloi, my lord. He passed away, my lord, on 2nd of November 2022, my lord.
So it all depends on the in whose name the registration is there.
It was in the name of Satyajit Bordoloi, my lord.
Hmm.
I have another certificate. Certificate of Lordship will
Where is
find it
that?
page 18.
So in respect of the dues payable under to the state and center,
My lord.
the legal heirs will be responsible.
Proceeding was against the dead person, my lord. That's what I'm saying.
The proceeding was, how will the department know that he is dead unless you inform me?
My lord.
There was no intimation that he had expired.
Lordship will fix tomorrow. Let them put in the notification of extension if it is there, my lord.
Can you produce it tomorrow? Tomorrow?
My lord.
Let us have it tomorrow.
My lord.
This matter tomorrow. As standing counsel, PST, that there is a notification, further notification, extending the time pursuant to the notification dated 23rd,
28th of December.
28th
My lord.
of
December
December
20.
2020. List the matter. 28th.
No, this one regarding force measure, my lord. So Lordship has fixed the matter on 22nd of July, my lord. Apart from that, my lord, I have some other grounds also, my lord. This order has been passed in violation.
And the counsel for the parties issued notice. Second,
My lord.
similar matters are fixed on 27. Therefore, the question raised in the petition is whether COVID-19 is the ground. COVID-19 can be interpreted to understand the meaning of force majeure as prescribed under section 16 capital A of the CGST Act. Mr. SCKL and standing counsel as well as Mr. D. Boyler, standing counsel for state PST and PST submits that there are judgments of the High Court of Kerala,
Kerala and Allahabad.
Allahabad High Court, which have decided this issue and dismissed the contention raised by similar matters have been heard. With this matter also treated to be partnered and question of law which will be decided in this matter. All these matters listed together on 22nd of July.
Yes, sir.
But till then, no coercive action, my lord.
Till then, no coercive action.
Deeply obliged, my lord.
Against the writ.
Sorry, my lord, I must have got it.
Yeah.
My lord, this it's very innocuous. I don't know
how an order has been passed by the circle officer doesn't have a jurisdiction also. There is a gift deed which was in my name, which was given by way of a gift deed by my grandmother. Now my brother is against this gift deed and is saying that this is a forced gift deed. Now he lost an FIR. I took a bail, anticipatory bail. Thereafter, he makes a complaint on the basis of before the revenue department. And my lord, when we appeared, notice was issued to us. 2 applications were filed. We said, please give us the copy of the complaint respective document, not being provided. Second time we went, then it was provided. Then we filed a preliminary objection. We said to the circle officer, you don't have a jurisdiction also. If you are challenging a force deed under 41 of the Assam Land and Revenue Regulation, my lord, it is only before a competent court. Kindly see this, my lord. And the matter is under investigation by the police. Kindly see, my lord, the the notice which you have served to us. At page 40, my lord, will kindly see. First notice, if your lordship will kindly see at page 36. First, your lordship will kindly see the gift deed at page 23. This is a gift deed. 23 is a gift deed. Gift deed 24th of December 2007. On the basis of the gift deed, which is 2 kata 10 lectures, we are in possession of that land. Debojani Chaudhary, and this is my grandmother, which is given to Tridip Chaudhary, which is a petitioner, the grandson. Now this is being gifted. On the basis of this gift deed, my lord, there was an FIR which is being lodged by my brother. My brother at page 31. What he says, my lord, on the second paragraph, he makes a description on the first paragraph, the plot of land measuring so and so. Second paragraph, on an RTR reply received by me on 6/5, by letter number so and so from APDSL regarding the change of consumer electricity number in the name of Tridip Chaudhary, it has come to light that Tridip Chaudhary, by submitting a forged gift deed bearing number so and so, purported to be executed before the office of the senior sub-registrar Kamrup, along with a false affidavit stating the time of death of our grandmother late so and so, had left behind Tridip Chaudhary as only the legal heir, which is completely a false declaration made by him. So this is so on, he goes on.
Any suit filed for cancellation?
No, that's the whole case. They have not filed. And if your lordship looks into 41, kindly see 41 miles of the Assam Land and Revenue Regulation. 41. Hey, no, new amendment. No. Yes, right.
Yes.
So 41 kindly be seen now. 41, section 41 of the Assam Land. Entries in records and their effect. Entries in the records made under section 40. So mutation is in my name. I am in possession. Shall be founded on the basis of the actual possession. All the dispute regarding such entries, whether taken up by a settlement officer of his own motion or an application of party concerned, shall be investigated and decided by him on that basis. And all the person, and now kindly see, read this minor, and all person not in possession, but claiming the right to be so, shall be referred by him to the proper court. That is the civil court. Now there has to be cancellation of the gift deed. On the basis of mutation, we will be cancelled. Thereafter, the investigation. No, matter is already investigated, my lord. If he is really aggrieved, let him file a civil suit, my lord. He cannot. And what has happened on the basis of preliminary objection which you have filed, he sends 4 of the police officers, 2 of the lot mandals, and they said we'll now demarcate. Where is your power? That is why we have come up before this court. We have made a specific averment before the court. Kindly see, my lord. Page 12, kindly be seen, my lord.
Yes.
Para 17. Para 17. That after the filing of the, at page 12, para 17. That after filing of the aforesaid preliminary objection by the petitioner, raising maintainability of the proceeding, respondent without deciding said preliminary issue on 21/6/2024 at about 1 p.m. sent some official from his office along with some police officer from Gitanagar police station without issuing any prior notice to the petitioner to demarcate the land in question illegally and in collusion with the respondent number 4 and tried to demarcate the land. After seeing the same, when the petitioner asked the official to show him any office order notice to the effect, they failed to show any such order notice and told the petitioner they have come as per instruction of the respondent number 3 as there is no such written order. After hearing the same, petitioner did not allow the official from the dispute revenue circle demarcate the land. However, the said official told the petitioner they will again come and they will hand over the possession of the land to the respondent number 4. It is further mentioned herein that in a complaint dated 5/3/2024, respondent number 4 has not paid for demarcation of the land in question, but respondent number 3, without any application of mine, without any sanction authority under any law, by misusing his official capacity and his official to the land in question, that too without serving any prior notice to the petitioner. Therefore, such conduct of respondent number 3 clearly shows his ill intention. Under law, my lord, 41, you are saying that this gift deed is forced. You go before civil court, cancel it. And where is the power? The police is investigating. They are troubling unnecessary.
In instructions, my lord, notices may go.
Heard Mr. Digas, assisted by Mr. S. Deca. Appearing for the writ petitioners and MS.
2 and 3, my lord. 1, my learned friend.
The authority of petitioner is agreed by the. Is there any order passed by the?
No.
By his agreed by apprehended. Is agreed by actions taken by circle officer, revenue circle, to demarcate a portion of land, demarcate the land, which is in his possession.
I'm in possession, yes, long back.
Which is in his possession. Stop the measure of land is water state letters covered by target 89/19 323 of Patta number 34 village Rapurigo to the Belpona. Stop. It's submitted that this land was gifted by execution of a gifted on 24th of December 2007 by the donor,
grandmother,
Srimati late Devajani Chaudhary, grandmother, the petitioner, as well as the donor. Stop. In pursuance to an FIR lodged by the respondent with the police station, making allegation that the gift deed is a forged deed. The respondent, the circle officer, circle officer has made attempts to demarcate the land for the purposes of petition. So, council referring to section 41. Regulation 41.
Yes.
The Assam Land Regulation submits that under the regulation, if any person who claims to be the owner of the land but not in possession is ready to be referred to the competent civil. As such, circle officer has no jurisdiction to entertain this matter. Stop. To the best of his knowledge, there is no civil suit pending questioning the gift deed. authenticity of the gift deed. Only an FIR has been filed and investigation in that respect has carried on by the IO and the petitioner is being arrest and also obtain an anticipated date. And such circumstance, that the respondent number 3 should be directed, should be suitably directed not to take any steps to demarcate land without there being a proper till the matter is decided by competency. Contrary to the, not to demarcate the land contrary to the claims of the requisition. Till competency like that. Is there now
Yes,
what is
My
your
lord,
apprehension?
kindly see 21. We said that 21 prayer. We have asked for stay of their impugned proceeding on this case.
What proceeding?
That he is initiating circle officer
Where is that proceeding detailed?
56 of 2024.
Page?
Notice has been sent.
Page
Page, it starts from page 36.
36. So why should we stay this proceeding?
Otherwise he will go, he doesn't have a jurisdiction. 56. The proceeding, where is the jurisdiction? If it is a gift deed has been forced, then it is only, he doesn't have a jurisdiction.
We give you the protection, but you have to agitate this matter before the competent authority. Why
We have
proceeding
agitated.
should be stayed?
Preliminary objection has been filed.
That's right.
Page 48.
Let the proceeding carry on.
But they will not take any coercive measure. No coercive measure, my lord.
Let the respondents obtain their instructions in the matter. And they see prima facie until and unless the ATC passes an order, the circle officer passes an order. Can we restrain him from proceeding?
No, he is not taking, he is not passing any order intentionally. He is sending his person to my residence. That's not the way you will do it, my lord. That's the whole problem, my lord. No coercive measure should be taken.
No, what coercive measure?
He is
Coercive
taking,
measures for what?
he is taking, he is sending to take, his only intention will take the possession, demarcate it and take the possession, throw me out. This is the whole difficulty, my
No,
lord.
no, but there is a process for doing it.
I'm sorry?
There is a process for doing it.
He does not,
why are you apprehending?
he does not have the jurisdiction also to initiate this proceeding, my lord. That's
That's
the
right.
whole case.
We will decide on this matter.
No,
But
it's
at
true,
this
my lord.
stage, to stay the entire proceeding.
Then he will go ahead, my lord. Then he will go ahead.
If he goes ahead, you have to challenge this order. Then
He'll take the
provisions for an
consequences,
appeal.
my lord. If he does
my lord,
anything
if he
illegally, he'll take
doesn't
the
have a
consequences.
jurisdiction, can he file this, can he send a notice to me?
That's right. But there is a proceeding initiated. He being an authority, he has to pass an order.
He doesn't pass, that's the whole problem,
That's
my lord.
right.
He's in collision with the private respondent.
Have you named him in person?
No, I have not person, my lord. He's a circle officer, my lord.
So,
Not in circle
you
officer.
are making allegations that he's in
But,
collision with
but,
respondent.
my lord, but he should not take any coercive measure by taking
What coercive measures are you apprehending?
possession in respect
How
of
can
the.
there be a possession by the circle officer?
He's doing, my lord. That's the whole problem, my lord. That's the whole problem, my lord. He's doing it, my
His
lord.
allegation, my lord.
So he is only sending some persons to, I don't know, maybe to take measurement or whatever.
Can he take, my lord? Can he take this measurement under the law? Where is the question? Is there is no prayer for demarcating this land?
Where is that application?
Yes. 43 is there.
It's the replica plan.
Same FIR is say, kindly see 43. 5/3/2024, reporting courts give deed. I am writing to bring your attention concern finding related property as house number so and so. As a legal error of so and so, I identified several alarming issues. A photocopied purportedly registered gift deed.
There is some other mutation case pending here.
Where?
Page number 44.
Yes.
There is some mutation case pending again.
No, that has been filed by him, my lord. That mutation. mutation, failure to produce, I have lost the concern, APDCL, same contention which I have raised in the FIR. Kindly see the FIR, my lord. Kindly see the FIR.
No, see, if you see the notice at page 36,
Yes,
it is the miss case number 50
yes,
on the strength of some complaint.
yes,
But in this particular page number 44,
yes.
there is the reference to some other mutation.
But Marty, my lord, kindly see the bottom.
46. Bottom.
46, my lord, kindly see bottom. You say miss case 56 of 24 in 46, my lord. 46, if you see on the last down bottom.
No, no, what we want to know is the circle officer, whether he has the power or not under the provision, he has to pass an order.
Yes.
He has to pass an order.
He is not.
If we stay the proceeding, how will he?
No, let him pass an order, then my lord, no coercive measure should be taken. In respect to the position of the petitioner, I am in possessing, my lord. I am in possessing that property.
So therefore, we are asking you in which matter you are apprehending eviction from that particular land.
56 of 2024, where a miss case has been, my lord, issued, a miss case has been registered, notice has been sent on the basis of the gift deed which has been executed, which I am in possession.
Is page number 36, the case referred here, is this the case that you are apprehending?
That's an earlier mutation, my lord. Earlier mutation case.
In my
Earlier mutation which was in my favor. Which was in my favor, my lord. Case regarding cancellation of record, correction in connection miss case. So, my lord, on the basis of gift deed.
So see, you are asking for an interim order. Whether the authority.
I'll tell your lordship. Please hear me. The gift deed was executed. I am in possession of that property. On the basis of the possession, a mutation has been applied. On the basis of the records of right was in my name. Corrected. Now, what has happened, my lord? He files an application before the authority for cancellation of records of right, which was in my name, which you are looking at page 36.
alleging that
This alleging that that particular force deed is a gift deed. On the basis of that, he files a mutation. Now, one, he cannot cancel the mutation without the gift deed, which is still
passed an order for cancellation.
yes, yes.
That I know, my lord. He has not passed. But the only is circumventing all this. He is trying to hand over the possession.
So
Throw them
you
out.
should array him as a party. That if he's playing forgery, if
No,
he's
no,
in
he's-
connivance with the private respondent, then you have to array him as a party. Otherwise, see, he has a case before him. According to you, he cannot pass an order. But he has not passed an order.
He has no jurisdiction to pass an order. This notice itself is
It is for the authority to decide whether they have a jurisdiction or not.
in the meantime,
Can a different authority decide whether?
no, let him decide. But in the meantime, he will give the possession to him. Lot Mandal is
But
coming,
it
they
is
will
still under
demarcate.
your possession, that is what you said.
I'm in my possession.
Ah.
I'm in my position. My position should not be disturbed. My position should not be disturbed. That's what I am saying, my lord.
That will be a matter to be examined by a civil court, my lord.
Let notice be issued on the interim prayer. Returnable on the same date. Till the next returnable date, tell us when you can get your instructions. 29th July? 29th July?
My lord.
Returnable on 29th July. Till the next returnable date, the possession stated to be the possession of the petitioner as claimed shall not be disturbed without leave of the court. Possession of the writ petitioner on so and so land.
Yes, on the land.
On the land demarcated in annexure
Mentioned in the gift deed.
the gift is stated
Yes.
to be in possession of the writ petitioner shall not be disturbed without leave of the court.
In the prayer also we have mentioned. Yes, deeply observed.
Please, your lordship. Lordship, item number 16, lordship, can it be taken as last motion matter?
Why?
Lordship, I am awaiting one instruction, lordship. Last motion matter. 16, lordship only.
But on 22/7, my lord, similar issues are coming up. Our lordship has already fixed item 15. Same issue, my lord, same
Lordship,
notification.
but I would like to only last motion.
Yes.
Application.
17. Only it is 17. 17.
Same, no?
Lordship, in item number 17, lordship. Lordship, there are two issues which we are challenging in this lordship. We have come directly against the impugned time barred order dated 28/3/2024. Lordship, the other issues regarding the lordship force major clause as well as recommendation of council and lordship, these are there. Apart from that, lordship, the major issue which is there in this writ petition is that lordship, I am challenging that lordship 16(4). Lordship, I am not challenging the provisions of section 16(4). Lordship, when I lordship purchase a good from a supplier and I sell the goods, I am entitled to an ITC on the tax which I have paid to the supplier. Now, lordship, that ITC which I am getting, lordship, section 16 puts a bar to it. That you have to all the filters which has been put under section 16, you have to cross that, lordship, section 16. Section 16. So, lordship, section 16(4) puts an embargo. Lordship, I have paid my tax to the supplier. Supplier has paid to the government. This is the case, lordship, my case. But lordship, section 16(4) says no, you can't take the ITC unless and until you have filed your returns on time within the prescribed period under section 39. Lordship, 16(4), a registered person shall not be entitled to take the ITC in respect of any invoice or debit note for supply of goods or both after due date of furnishing of return under section 39 for the month of September following the end of the year to which such invoice or so and so pertains. Lordship, this
Proviso.
lordship
Proviso.
provided that the registered person shall be entitled to take input tax credit after the date of furnishing return under section 39 for the month of March 2019 in respect of any invoice. Lordship, it's only for the month of March. In respect of an invoice relating such year, debit note for supply of goods or services or both made during the financial year 2017-18 and so and so. Lordship, my case is relating to 2018-19. This proviso will not apply to me. Lordship, now what has happened, Lordship? This Lordship, Lordship provision. Lordship will see that since Lordship is seeing the amended provisions, it is written Lordship in the section 16 for 30th day of November. 30th day of November is written. Lordship may kindly see the second line, both after the 30th day of November. Lordship, this is the amended provision. When 2018-19 was there, this amendment was not there. Lordship may kindly see the subnote.
Yes.
It was, Lordship, earlier it was September. This has been amended, Lordship, with effect from Lordship 1/10/2022 by way of Lordship notification. Lordship, may I present?
Yes.
This notification section 100, next page, Lordship. This was the Finance Act 2022, Lordship, section 100, subclause B. B says, in subsection 4, for the words figures, due date of furnishing of return under section 39 for the month of September, the words 30th day of November shall be substituted. So, Lordship, for the future period, it is November, last date of filing the return. So,
It is substituted by 30th day of November.
yes, Your Lordship. Now, Lordship, so far as my case is concerned, Lordship, my case is relating to the assessment year 2018-19. For me, Lordship, the period of September only will be, Lordship, included. So, Lordship, I had filed the date, the return after September, but Lordship, before November, 30th day of November. So, Lordship, I was, Lordship, praying that just 14 days of delay is there, Lordship, in my case, 14 days of delay is there. Lordship, in a similar case, Lordship, the Kerala High Court has held that this is condonable because, Lordship, that time the glitches were there. When you were allowing the Lordship from 2022, you are allowing the persons to file the return in the month of November and allowing them to take credit after November. Lordship, that time it were glitches. People were filing returns delayedly. So, Lordship, the Kerala High Court has held. Lordship, this has been accepted by the GST Council also. Lordship, may kindly, Lordship, this judgment, Lordship, page 35, if your Lordship may kindly see. Page 35. This has been accepted by the GST Council, Lordship. They have given some effect, but Lordship, my order has already been passed. 35.
Good.
Paragraph 33, Lordship. Delaying making the entries within the time fixed should not be the basis for denying the benefits of ITC. This is my submission, Lordship. It is further submitted that ITC is a facility of credit and it is in the nature of vested rights. The credit earned under GST is the property of taxable person. Therefore, denial of ITC would be violative of so and so. This substantial benefit cannot be due to procedural lapse of mere non-disclosure of GST or PB within the due date, since the details of ITC are already available in so and so, which is available with the department prior to due date of prescribed under section 16(4). This was the submission, Lordship. Lordship, thereafter, Lordship, may kindly see page 87, where the Lordship, the judgment is there. Herein, Lordship, the 16(4, Lordship, they had challenged the 16(4) provision also. That was not taken into account, but Lordship, the delay was condoned. Only a High Court under the Lordship provision of Article 226 has the power to condone this delay. Page 87.
Okay.
Lordship, fifth line from the top. The amendment is only procedural to ease the difficulties initially faced by the dealers, taxpayers. Therefore, when the period from 1/7/2017 till 30/11/2022, if a dealer has filed the return after 30th September and the claim for ITC was made before 30th November, claim for ITC of such dealer should also be processed if he is otherwise entitled to claim ITC. It has also been pointed out that in several cases which are pending before this court, the claim has been made before 30th November of the succeeding financial year, but the relevant period was 20th October, which was extended date for furnishing the return under section 39 for the month of September. Therefore, if a person has furnished the return for the month of September till 30th November, their claim should also be considered and processed and should not be rejected if the dealer did not furnish the return for the month of September on or before 30th October. Because this amendment being procedural has to be given retrospective effect. Lordship, Lordship,
You filed your returns when?
my returns were filed, Lordship, in the month of November, Lordship. I filed it on 4th of November. So there was a delay of 14 days. Lordship, this has been accepted.
How is it 14 days? In your case, it was in September.
September, Lordship, it was extended to 20th October. Lordship, may kindly see the GST Council, Lordship. Yesterday I was asking, Lordship, the GST Council recommendations are also there. This is the paper, Lordship, press release. Lordship, may kindly see the second point itself. Lordship, this is accepting the judgment of this Madras High Court, Kerala High Court. GST Council recommends the time limit to avail input tax credit with respect to any invoice or debit note under 16(4) of CGST through any GSTRB return filed up to 30/11/2021 for assessment year 17/18, 18/19, 19/20, and 2021 may be deemed to be 30/11/2021. They have accepted that November should be the date. Lordship, but this is just a press release, Lordship. This will come into effect. The no notifications have been issued as that. It will take a lot of time. So my humble submission is, Lordship, I'm at this stage, Lordship, praying for a Lordship interim inspection and Lordship notice may be issued. So far as Lordship, this time bar order dated 28/3/2024 is concerned for assessment year 2018-19.
In your case, the ITC was rejected, denied.
Denied only on the ground. Otherwise, Lordship, I had paid the tax,
But
the same has been paid to the government.
there are two different issues here. Why
Yes.
you,
Well, Lordship, notification has already been issued. And
one is this extension of the delay. One is this limitation.
Limitation, Lordship, in this case is there, but Lordship, Lordship, I am only harping on 16 because Lordship, that is a more pressing issue. Lordship, that limitation,
No, I'm asking you if you're pressing that point or is it only 16.4?
Lordship, at this moment, for the purpose of Lordship, taking an interim order, Lordship, I am only at this moment, Lordship, pressing on this 16.4 issue. Lordship. And I'm asking for a condonation of delay from this
No,
honorable.
but then we'll have to record it that you're not pressing 168A.
Lordship, I am 168A is also one of my Lordship prayer in the petition. And Lordship, 168A, Lordship, I have got other arguments, not only force major. There are other issues which I want to challenge in the so far as limitation period is also concerned. Lordship 56/2023, which the notification due to which the limitation period has been extended for the year 2018-19. But Lordship, my this suffice if I am Lordship. That may also be noted, Lordship.
Yes, Mr. Gogoi.
Here also page 131 of this petition. Relevant portion, the what my learned friend has mentioned is it is in the 8.3, 8.4 and 8.5. 16.4 is, may I read your lordship, 8.3. The constitutional validity of 16.4 of the CGST Act 2017 was put into question before the courts of India. Recently, the Andhra Pradesh High Court in the case of so-and-so 2023 7 TM states that, I read the paragraph 25, your lordship, relevant point. Though the above discussions deal with the ITC claim related to the concerned state laws, however, concept of ITC is one of the same, and those decisions will equally apply to the case on hand. Thus, it clear that the ITC being a concession benefit rebate, the legislature is within the competency to impose certain conditions, including time prescription for validity, availing of such rights, and the same cannot be challenged on the ground of violation of the constitutional provision.
Not telling the validity of 16.
And accordingly, on the basis of this judgment, the observation have been made. And that is a punitive part is under part on order. That is the amount. Your Lord.
Not challenging it. We are, this is not a
Agree by order. Where is your impugned order?
my impugned order. Page 121.
Dated 28/3/2024 by the Richard. Confirming a tax amount of 9,494.57 for excess/wrong payment of input tax credit for the financial year 2019 in terms of section 7(3) of this year. Act. The amount was already deposited by the commissioner and the same was returned to the agreed. Demand of tax amounting to 10,606 has also been confirmed, along with the demand of tax 35,894 on inadmissible items. Further order passed imposing late fee for certificate ID ESTR amounting to 300 and penalty of 4,47,500. Imposed was imposed. Council for that essay to the same order of ground trustee that the proceeding are timered and therefore proceeding the extension of limitation in terms of limitation by its plan of Kerala High Court under the MS Trade Links Association of India, second of 59 of it submits that the Kerala High Court has similar matter can avail the claims of input tax credit benefit in respect of the commissioner there. So submitted that this benefit amounts to a vested right of the petition. Therefore, the same cannot be taken away. Even if there is something in compliance with the program. Certain council and further rapid press note released to refer to the 53rd recommendation of the 53rd PST submit that the time limit to avail the input tax credit with regard to any invoice or debit note under section 64 of the CST Act through any STR return filed up 30/11/2021 for the financial years 2017-18, 19-19, 19-20 and 2021 is deemed to be 0/11/2021. So, Senate Council that is the recommendation of the GST supports the contention raised by the reflection that notwithstanding supports the convention of the reflection that the time limit to avail the input tax credit in respect of the financial year in concern, which is 2018-19, should be deemed to be 30/11/2021. So, in that respect, the denial of the payment of input tax credit by the valid law and corporate that the permits at least that such option and during the finance Mr. Dr. Boy studying up on the other end refers to
8.1, 131 page. 8.345.
submits that the Andhra Pradesh High Court in so-and-so case number like 121 in similar matter had held that the withdrawal or denial of ITC benefits cannot be challenged on the ground of violation. Therefore, there is no infirmity in the issued order. There is no infirmity passed by extent of petitioner had paid for 5 that. Therefore, by the order, the ITC was correctly denied. So, he, however, submits that he is yet to receive complete details of the recommendations of the 53rd GST. Considering the issue of the respondent represented by the having been represented, this is the way now has gotten defied their affidavit. Let this matter also listed along with other similarly other similar matters fixed on 22nd of July. In the meantime, the next week fixed, no big action shall be taken against the resolution in terms of the reviewed order dated so it's a past date.
Lordship, item number 20 and 47, both are similar.
See that. 20 and
20.
Yes. Where is that impugned order?
Lordship, the impugned order is page 187.
Impugned order at page 195.
Lordship,
Is the effective operative
Your
part
Honor.
of the order?
yes, your Lordship.
195. Impugned order dated 12/3/2024.
As well as Lordship, their demand notice or DRC 7, 1/5/2024. They have issued a
Marked by 20. As well as
DRC 7 dated 1/5/2024. Earlier it was notice
Okay.
of demand, Lordship. Notice of
Right.
demand.
we are giving you no interim protection.
Yeah.
Order.
Your Lordship, here in this case, 9.0, my state.
47.
Impugned order
Lordship, page 113, 29/4/2024. 113.
impugned order dated 24. By the Government of State Bank. Second copy. Double 341. Your AOR has kept these papers upside down, so it's becoming a little difficult to. Huh?
Okay. Lordship, and Lordship, what happens? The state is given different type of order. The central is given different type of order.
Sorry?
Order is at
Where
page
where is that order? If you know.
Lordship, 113, 113.
But there is no denial of ITC here,
Lordship, the
the
ITC,
recital of the order.
the Lordship, in the order, Lordship, they are confirming the SOCO's notice. Normally, Lordship, this is what the
Right.
state government are doing. They are mainly confirming the SOCO's notice. SOCO's
Where-
notice
where
is
is the
at page
SOCO's?
106.
106.
Yes, Your Lordship. SOCO's notice is na 106. नहीं, नहीं, 106. Lordship, page 99. 106 में मैं reply.
Right. Order. Confirming the access claim of ITC.
No positive.
It is rectified.
Yes, Your Lordship. It was opened check.
The next to check. ये दीदी मोहन
It is 19 है हम लोग का ना?
Yes.
May 3. My lord, here, my lord, a SOCOS was issued, my lord, against which order was passed. I preferred an appeal, my lord. Appeal was dismissed as time barred, my lord. My lord, while passing the order, my lord, the appellate authority has not considered the extension of limitation granted by Supreme Court, my lord.
Yes, Mr. Yep.
Lordship, first my submission, Lordship, there is an alternative remedy under section 86 of the Finance Act. Appeal lies to the, and Lordship, may please to see page 141. Paragraph 12.
141. Yeah.
Serial number 3 of the section 85 of the Finance Act provides that an appeal shall resume within
You're
present
reading
day
from page
with page 141.
141. Para number?
Para number 12.
There is no 12 here. 11 and then
Lordship, stamp is there, probably it is in. And serial number 3A of section 55. The Finance Act 1994 provides that an appeal shall be presented within 2 months from the date of receipt of the decision of the order such adjudicating authority made and after the Finance Bill 2012 received the assent of the President relating to service tax, interest and penalty. Then paragraph 13. Going by the above mentioned serial number 3A of section 85, the period of 2 months in the instant case would have expired on 12/4/2022, whereas the appeal has been filed on 27/5/2022. Even 1 month extension of the Commissioner appeals can allow for expiry of 12/5/2022. Further, I examine the delay in terms of judgment of the Honorable Supreme Court in Somoto number so and so, wherein in para 3 has been ordered in case where the limitation would have been expired during the period from 15/3/2020 till 28/2020, notwithstanding the actual balance period of limitation maintained, all persons shall have limitation period of 90 days from 1/3/2022. In the event the actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that the longer period shall apply. Since the expiry of limitation period in the instant case is falls beyond 15/3/2020 and to 28/2/2020, the benefit of the aforesaid judgment is not applicable in the instant case, and as such the appeal was dismissed on ground of limitation. Lordship, then come to page 133, Lordship. Paragraph 2A.
Two?
2A, last, page 133. In any other case, the appeal shall lie under section 87 of the Finance Act 1994 to the Custom, Excise and Service Tax Tribunal at Calcutta within 3 months from the date on which the order sought to be appealed against is communicated.
Further appeal not filed.
No, my lord, coming, my lord. What happened is that, my lord, the appellate authority has wrongly interpreted Supreme Court's order, my lord. Supreme Court orders say, my lord, Lordship will say suo motu order at page 127, my lord.
Yes.
My lord, relevant paragraph, Lordship will find at page 129. One 29, my lord.
Yes, yes.
May I read, my lord?
Yes.
The order dated 23/2020 is restored, and in continuation of the subsequent orders dated 8/3/2021, 27/4/2021, and 23/9/2021, it is directed that the period from 15/3/2020 till 28/2/2020 shall stand excluded for the purpose of limitation as may prescribed under any general or special law in respect of judicial or quasi-judicial proceeding. Now, my lord, the order was passed on, my lord, 2/2/2022, my lord. So, my lord, till 28/2/2022, my lord, there will be no limitation, my lord. Limitation will be counted from 1st of March, my lord. And Lordship may see paragraph 3, page 130, my lord. In cases where limitation would have expired during the period 15/3/2022 till 28/2/2022, notwithstanding the actual balance period of limitation remaining, all persons shall have a limitation period of 90 days from 1st of March 2022. In the event any actual balance period of limitation remaining with effect from 1/3/2022 is greater than 90 days, that longer period shall apply. My lord, my contention is that, my lord, I am entitled for 90 days from 1st of March, my lord. And if the limitation is counted from 1st of March, my lord, my appeal is within time, my lord. It was filed, my lord, on 27th of May, my lord.
Your limitation expires when?
My lord, the counting will start from 1st of March, my lord, because, my lord, order,
Had this order not been there,
my lord,
when would your limitation would have expired?
would have expired, my lord, it would have expired on 12th of May, my lord, 12th of April, without condonation, with condonation, 12th of May, my lord.
Of 2022.
2022, my lord. If this order would not have been there, my lord.
Yes, Mr. K.
Lordship, paragraph 13 is clear. Lordship, the Supreme Court judgment was taken into consideration.
No, but from
Even
the,
if-
from the
even if-
dates which are given,
Okay.
from the dates which are given, show,
Yes, sir.
it says, para 13
Yes, Lordship, it has been quoted here in paragraph
would have expired on 12/4.
12.4, then they filed appeal on 27/5/2022.
Hmm.
It should have been filed on 12/5.
No, in case of, in page number 130,
Then
there is a further limitation for 30 days, sorry, 90 days.
Yes,
From
sir,
1/3. So 1/3, 90 days will be
that is-
1/4/15.
see, that has been quoted. Lordship, here, the question of interpretation will come.
What interpretation?
Lordship, that has been explained in paragraph 13, page
No,
1.
first, let us understand in case of serial number 3 at page 130.
My lord.
What is the maximum period that you have?
I would have 90 days, my lord, maximum.
No, 90 days from 1st of March.
1st of March, my lord.
Which will expire when?
On 29th of May, my lord, if 90 days is counted, my lord, because
29th of May.
my lord, 31st, in the month of March, my 31 days there, then April 30, then my lord, 29th of May, it will be, my lord.
So 29th of May, apparently.
No, Lordship, let me come to page 141.
Yes.
Lordship, paragraph 13, I again reading. Going by the above mentioned, serial number 3 of the section 85 of the period of 2 months from the instant case would expire
expired on 12/4/2022, where the appeal has been filed on 27/5/2022. Even as 1 month as extension of the Commissioner's appeal can allow for expiry on 12/5/2022. Further, I examine the delay in terms of judgment of Honorable Supreme Court in Somoto, writ petition number so dated 10/1, which has been referred by my learned friend. Wherein in paragraph 3, it has been ordered that in case where the limitation would have expired during the period between 15/3/2022 till 28/2/2022. Dr. Lordship, the limitation expired in
So it is only for those cases where limitation could otherwise expire prior to 28.
yes, within 28/2/2022. Then Lordship, they will. Lordship, even the interpretation of the authority may be, suppose for the argument's sake it is wrong. Provision of appeal is there, they can place all these things before the learned session law.
But my lord, appellate authority is not read para 1, my lord, of Sumoto order, my lord,
Yeah.
which says it will exclude, my lord. That period will be excluded for the purpose of limitation. From 15 March 2020 till 28/2/2020, it will be excluded, my lord.
No. So you are filing an appeal. You are filing. When was the original order passed?
The original order was passed on 2/2/2022, my lord.
2/2.
No. Lordship, appellate order 31/7/23.
No. Original order.
Original order, Lordship,
02/02/2022.
2022.
Page 104, my lord.
So what is the period for appeal?
My lord, from date of communication, my lord, 2 months,
2 months, 60 days.
60 days.
So it would be 3rd of April.
My lord,
Sorry.
from the date of communication, it will be 12th of, my lord.
12/4.
It was
12/4.
12/4, my lord. 12/4.
So you should have filed an appeal within 12.
My lord, if,
Within 12.
my lord,
Now the period excluded from 15/3/2022 to 28/2/2022.
my lord.
Doesn't affect you because
No, my lord, if I will count my limits, my
you
lord.
will get till 28/2/2022.
My lord,
So you'll get about 26 days.
my lord, around 26 days.
26 days. So 26 days means
Yes.
a 27th or
My lord,
27th of April, May.
May. And I filed on 27th of May. In that way also, my lord, perhaps, my lord, I will be covered, my lord. Lord, similar order, I am relying upon, my lord, in similar case, my lord, coordinate benches pass some order. Let us head side, my lord, paragraph 3, my lord. But even if, my lord, Lordship may remand it for hearing the matter on merit, my lord.
Para 3.
My lord.
Para 3.
Para
So
3.
you give us the dates.
Well, dates I am giving, my lord. Date, order was passed on 2nd of February.
Where have you stated in the body of the writ petition? Is it there?
Yes, my lord. The order I have annexed, 104 is the order, my lord.
Have you stated in any paragraph?
My lord. Paragraph 18 I have explained, my lord.
Paragraph
18, page 15, my lord.
18, yes. I think, Mr. Kyal, it appears to be within limitation.
No, Lordship, there is a the promoter order lordship, please come to clause 1 and clause 3.
See, there is no dispute that the period from 15.3 to 28.2 is excluded.
In paragraph, paragraph 3, page 130.
Yeah.
In case where the limitation would have expired during the period.
No, we are not on this. We are only on the first paragraph.
No, lordship, because this is also part of that order. That was taken into consideration by the appellate authority while considering the application of.
No. This is not applicable to him. Para 3. Is para 3 applicable to him?
Obviously, no. Lordship, in fact, lordship, there is a contradiction between clause 1 and 3.
No. The clause 1 says 15.3.2020 to 28.2.2020.
It is right that the period from 15/3/20 shall be
Excluded.
excluded for the purpose of limitation is the it may be prescribed under
So
general
therefore,
or special
the
law.
order in original was passed on 2nd of February.
Yes, sir.
So he'll get a benefit till 28.2, which is excluded by the order of the Supreme Court.
But if we go by the clause 3, then the interpretation may be different.
How?
Because because here said that
He gets an order.
if the period of limitation is expired between 15/3/2020 till 28/2020.
No, here the limitation does not expire. It expires after 30 days, isn't it? What is the period for appeal? 30.
60 days. 60 days plus
60 days.
60 days.
60 days.
60 days.
So from, let us say from 2nd, let us say it is from 2nd of February.
It was there.
Or 12th of February.
12th of April.
When was the order received?
12th of February, madam.
12th of February.
Then 12th
From 12th of February, 60 days.
60 days, 12th.
12 or 13 or 14, whatever date it is.
Yeah.
Right? Now, above that, he gets
30 days.
from 12 to 28.
No,
Another 3 more days he'll get.
No, here my explanation. At the clause 3, if the period of limitation expired between 15/3/2020 till 28/2022, here lordship their limitation expired on 12/4. So after 28/2.
That's right. So therefore, he doesn't get the benefit of clause 3.
Yes.
But what about clause 1? Entire block has been excluded.
That is my humble submission because there is some lordship will be interpreted if we read together 1 and 3.
How? Firstly, that benefit is given to it. It is to be then extended period of limitation. Supposing your let us say your order was passed on 2nd February. You'll get the benefit of limitation till 28 February.
No, that is correct. But here their limitation.
So you're counting, even if it is from 2nd February till 2nd of April, that additional 26 days will have to be given to him.
If separately we interpret clause 1, then lordship probably he
That
will.
is how it is to be interpreted. How else it is to be interpreted?
When we read clause 1 and 3, then probably
No. 3 is for where the period, where there is a limitation period which expired within that period. Then you get another 90 days.
Yes, that is correct. But here
Here it does not expire. So clause 3 is out.
No, look, because the order was passed on 2nd of February, and they get 60 days for filing appeal, and another 1 month. That means 12/5. So it is,
How one?
1 month is prescribed under the rule. So their limitation expires on 12/5 after 28. This is my humble sentence. This is my sentence.
So what will happen to the benefit of 28?
Because
your order was passed. See, otherwise,
No, that is
you'll have to count from 12/2. You'll have to count the limitation to 12/2, namely the date when the order was received.
that is the interpretation taken by the authorities while
I
interpreting
don't know,
clause
but
3.
whether you can do it in the face of this order saying that it stands excluded.
This point was for consideration before the learned judge who passed the order also. This was also for the reason because there is a contradiction between 1 and 3. And since there is no authority on
There
the.
is no contradiction according to me. One is that if a benefit
Yes, Lordship.
limitation
If,
is
if-
28,
then Lordship, there is no dispute, but
and 3 is where your
limitation expires.
limitation expires,
Yes.
then you get further benefit of 90 days. Limitation expires within that 28. But even if your limitation does not expire, the residual amount till 28 will have to be given to
No,
it as per clause 1.
Separately, if we consider, then Lordship,
Has to be considered that
my submission may be recorded. And
your submission is that since this limitation was beyond 28,
Yes.
he is not entitled to benefit under 1 and
Yes. This
that's
is,
it.
yes.
But you are disputing the submission that 1 on its own cannot be granted the benefit. It must be read with 3 on.
Yes, sir.
That your submission.
Yes, this is.
But primarily it appears that the benefit of 1 is to be given. Both are
That is,
mutually
that is,
hard learned counsel for the parties. It's aggrieved by the order in original 31/7. Commissioner appeals PTSD custom, whereby if the beat for the time card
My lord.
and dismissed. So the appeal was directed against the order in original passed by the Assistant Commissioner, PST and Cyber Excise, Kruger, dated 2/2022. So, Learned Counsel for the Commissioner submit that in view of the order,
One 27, my lord.
dated 10th of January 2022, passed by the Apex Court in miscellaneous application number so and so, page 127. The benefit of limitation as per clause 1, Roman 1 of that contract, of that order, was not given to the writ petition. And the appellate authority wrongly interpreted the provision and dismissed the appeal as holding it to the time bar. So, he therefore approaches this court praying for a that Mr. SCF, standing counsel against the respondent submits that clause 1 and clause 3 of the order dated 10th of January 2022 by the Apex Court has to be read together. And if done, then the period of limitation in respect to the writ petition expired after 28 to 2022. And therefore, he is not entitled to any benefit of extension of limitation and the impugned order and the order of the appellate tribunal impugning the present writ petition does not operate. Having heard that prima facie this court is of the view that the benefit of the directions contained in clause 1 in the order dated 10th of January 2022 passed by the Apex Court appears to be available in the writ petition, in which case the period of limitation in respect of preparing an appeal for the appellate authority would have expired on
12th of May, my lord.
12th of May.
Sorry, my lord. It not be, after excluding that part, it would be, my lord, 27th around.
Period interpretation of the so and so appears prima facie appears that the petitioner's appeal was not time barred. Accordingly, let notice be issued return respondent file their response and be listed after the return date. The matters are fixed on 22nd.
It is not similar, my lord.
be matter be listed again on 24th of July. Till the
Can it
next
be, my lord?
available date, the dispute order passed by the appellate authority as well as the order
Deeply obliged. Well, can you go 25th, my lord, if lordship allows 25th?
26th.
Deeply obliged, my lord.
May I please a lot? Lordship, in this case, Lordship, we have challenged the cancellation of registration. I have filed an appeal that was also rejected on the ground of delay. Lordship, my ground for Lordship cancellation, Lordship, may kindly see at page 69. The so-called notice which was issued. Lordship, Lordship, only.
Mr. Gogoi, any information?
No.
No information.
No.
Lordship, page
No,
69.
this is the first time it has come up.
This is
No,
for the,
no, there was an earlier matter also.
it will come tomorrow, Lordship.
But that matter, they were supposed to furnish some notification, which has been recent decision of the
The
matter.
GST council meeting, I have given Lordship.
What does it say?
Lordship, Lordship, in this case, it will not be applicable, but I will place this for the other case. Lordship, the recommendation, Lordship, the first recommendation itself for 17, 18, 18, 19, 19, 20. I'll give you the copy. Let me read. First recommendation. So the first recommendation says GST Council recommends waiving interest and penalties for demand notices issued under section 73 of CGST Act for the fiscal year 17, 18, 18, 19, 19, 20, full tax demand is paid. So if I pay up to 2025, all tax, interest and penalty is waived.
But nothing to do with.
Yeah, the registration.
Yes.
This is about registration.
Registration, I was just only that
Your registration was cancelled. It's not
cancelled.
about-
I was ready to pay the demand, but I was just
That's a different
contemplating.
issue, but it's not about penalties or demand
Okay.
notices.
Yes, sir.
Heard that,
Lordship,
Senate Council for the Petition.
Lordship, if Lordship may kindly, if you Lordship may allow, this is a bit different, Lordship. Only one page I will show you, Lordship. Page 69. Yes, your Lordship. Lordship, the so-called notice says the so-called notice says the Lordship. The reason is in the second paragraph. In case of voluntary registration, non-commencement of business taxpayer within 6 months from the date of registration. So they are saying that you have not commenced your business from 6 months from the date of registration. That is why they have cancelled. Lordship, my registration was from 6/10/2017. Thereafter, Lordship, so far as 17, 18 and 18, 19 are concerned, they have raised demands on me. If I'm not doing business, how the demands are raised? 17, 19, 18, 19. Lordship, the demand notice I have annexed.
Demand for what?
Lordship, the one is excess claim of ITC. There is interest. Tax payment has been done. Lordship, my registration is at page 31 and Lordship, my demand is at 34. 34 is the so-called notice for 17, 18. And the demand is at page 41.
They've already passed order.
Yes, your Lordship.
Which
Page 41 is the
These are not on
DRC.
the challenge.
Lordship, this they will take its own course. I'm not challenging so far as this stage petition. I'm only concerned about the cancellation, Lordship. Page 41, Lordship will keep the July 2017-18 excess ITC claim. So if I'm not commencing business, how is 17-18? Lordship, again for 18-19. Lordship, Lordship, I've got the page 41, 17-18 excess ITC claim. Then Lordship, page 46 is 18-19 order, demand order. This is the so-called notice, Lordship, that will be adjudicated for 18-19.
No, the page 41 is the summary order.
This is the final order, Lordship. DRC 7 is the final order.
Okay, third,
And
essentially will be cancelled. The order dated 19/12/2019. Proposed notice. And the order dated
31/12.
Proposed notice dated 19/12/2019 and the order dated 31/12/2019. That the GST registration for registration has been cancelled for non-commencement of business of the taxpayer within a period of 6 months from the date of expiration. The account that this is not a correct statement, as department has already issued proposed notice and passed summary order for on the petitioner for claiming excess ITC. Submitted that if the petitioner had claimed excess ITC, that by itself is evidence of the fact that petitioner was in business. Therefore, the ground for cancellation of the inspection. And there will be no appellate authority. There is no appeal.
No.
There will be no appellate authority prescribed under the Act. Present by frame. Mr. P. Goyal and study all this
No, my lord, 1 and 2 is central government. I am appearing for 3 to 5.
3 to 5. Mr. MS A. Sharma appearing for respondent one. Submit that they will obtain instruction. According to the notice, we should return it after 4 weeks. That's it.
But
Yes,
the
ma'am,
fixed
yes.
date may be given, but lordship, this will be disposed of.
Fixed date.
Otherwise,
24th,
yes, your lordship.
24th July.
What of-
Since study councils have already entered appearances,
No, let it be on my lord 35.
notices are
At least
waived.
4 weeks will be over there.
Furnished in a period of 1. You want it on
31st,
31st,
after 4 weeks. ma'am.
after 4 weeks.
Yeah.
Then we'll have it on
2nd of August.
2nd of August.
March.
What of-
May it please your lordship.
Yeah.
Lordship, your lordship, to protect the national highways, your lordship, guide banks were constructed, your lordship. And in this process, your lordship, lands were acquired, your lordship, those lands were acquired, your lordship. The compensation for house and giraffes were granted. Your lordship, what happened, your lordship? Since my house and giraffes fell under the guide band, your lordship, my APR form for payment this form is filled up because of as data for electronic payment, your lordship. And thereafter, your lordship, respondent number 8 approved my form. And your lordship, thereafter, your lordship, I didn't receive compensation. When I didn't receive compensation, I inquired. Then I came across the list of beneficiaries, which is at page 19. And I have come to know, your lordship, a person with identical name, your lordship, he has been granted compensation. And your lordship, his name is on serial number 17. But it is to be noted, your lordship, like other beneficiaries, where along with their name, your lordship, their father name is also enlisted. In this case, his father name is not mentioned, your lordship. And your lordship, his father has also received compensation, and his father's name is on serial number 18, your lordship. Thereafter, your lordship, I have filed a complaint case, your lordship, before the JMFC Sunitpur Tejpur, your lordship. The JMFC Sunitpur Tejpur, your lordship, by order dated, your lordship will find on page 29, annexure 4, your lordship, has remanded the matter to the OC of police, Jamaguri police station, OC police station, your lordship, but nothing has been done. I have been visiting the police station. They are not cooperating.
Will issue notice.
Yes, sir, lord.
Heard. Weeks, and Sharma appears for response.
3, 4, 6, and 9.
3, 4, 6, and 9. Even Dharpura for respondent number 1 to 5. Steps on respondent number 7, 8, and 10. By using code research. Respondents are at liberty to complete their just after return.
Your lordship, till returnable date, your lordship, the compensation which are left should not be, your lordship, released with regard to respondent number 10, your lordship.
Not without notice. Let them be on notice.
May it please the Lordship, the petitioner is clearly the duly licensed term tendered for the district and engaged in the occupation of distribution of sale of judicial and in the physical form. By the order dated government notification date 23/6/2003, the government discontinued the sale of physical of non-judicial stamps. Therefore, the petitioners applied for
Right.
empanelling them.
Notice that is being heard. Returnable 4 weeks. H. Sharma appeared for
2, 3, 4, 5, and 7.
3, 4, 5, and 7.
Oh, my lord, I'm sorry.
Here, on to for respondent 1. 1.
2
1
and
and
3,
1 and 4.
2 and 3.
3. So you are appearing for 1, 1 and 4. 1, 4 and 5 also.
5.
Mr. B. Gugoi for respondent number 6. Steps on respondent 7. I registered 4 1 week. Matter be listed after the and counsel the liberty. Respondent the liberty to complete their instruction. File necessary action. Yes, Mr. Patel.
My lord, I have challenged the order that is 17/4/2014 passed under section 148A D of the Income Tax Act, as well as the notice under section 148 of the Income Tax Act. Now, my lord, first of all, I am taking to
Order has been passed, reopened. Your assessment has been reopened.
not reopen. What has happened in this particular case, I claim that deduction pursuant to the section 80,
Show us which order is under challenge?
both the orders, my lord, at page 50, my lord, and 58. Your lordship will see
Yeah.
your lordship may come to page 53, my lord. The reason of opening of it.
So your objections were rejected.
My objection was rejected, and after that, this order has been passed. At page 53, my lord, since deduction under section 80I of the Act is allowed for a period of 10 years, the SSC company is eligible for deduction under section 80 for the year 2009-10 to year 2018-19. Therefore, claim of deduction for the assessment year is inadmissible. That is the thing, my lord. In this particular case, my lord, what has happened that no doubt originally the commercial production was started on 1/8.
We'll examine the matter. Your
yes.
Router, yes, Mr. K.
Lordship, here only notice has been issued directing them to file return. Alternative remedy is available to them if the final order is passed.
Alternative after filing. After the order is passed.
Lordship, please come to page 57.
Have you filed your return?
No. They're challenging it.
Because that's why, because I have challenged. It is without jurisdiction so far. Both the notices are concerned, those are without jurisdiction.
Counsel appearing for the petitioner, Mr. HKL, appearing for the Income Tax Department. Petitioner challenge the notices under section 148 and proceedings under 47 the Income Tax Act. Pursuant to the notice issued by the department, petitioner filed their objections, which came to be rejected, and notice under 148, the income tax has been issued. And the concerned income tax officer has to assess or reassess the income or recompute loss or the depreciation allowance or any other allowance deduction the assessment year 2020-21. So the petitioner was asked to file disbursement year 2020 and 20. This order is contrary to the law as reasons furnished.
Yes, sir, I have furnished the reason.
No.
That is the
Department.
objection.
Department.
Reason I have not furnished.
Reasons has
Still
been
the time
provided.
is there. That's why my lord is.
No.
Reason.
Reasons for
Reasons for
reopening the
reopening.
assessment. Did you ask for it? Was it furnished to you?
Pardon, my lord.
For reopening this process, the process of 147, 148.
Yes.
The authority, authority is bound to give you its justifications for proceeding for reopening.
My lord, here after issuance of the notice in section 48, that is
He submits that the grounds for reopening the assessment is procedure prescribed in the Income Tax Act not followed, and there is no material proceed for reopening of the assessment. Once therefore, approach this court for filing. Mr. SDL studying out that the matter is proceeded. There is adequate remedy for the petition to file proper appeal before the Commissioner appeal once any order adverse to the petition is passed. At this stage, no interim orders are called. Having heard the
my lord, so far the interim order is concerned. May I be heard?
You don't want?
No, may I be heard? So far the interim order, because so far the old notices have been issued under section 148 8D as well as 148 are without jurisdiction. Why those are without jurisdiction?
Hear the matter. Let them
No,
file.
yes, my lord. Till then, my lord, next day the stay may kindly be granted.
Day of what?
Or of this notice 148.
That matter be listed on the 2nd of August. Further proceedings, the so shall remain state the next 8 days.
Matter.
Yes. MSK Pupon appears for responsible party.
Petitioner in the year 2001 to purchase the land measuring 14 lakhs. But thereupon the DUG number was wrongly written, so we have filed an application for correction of the DUG number. Instead of DUG number 111, instead of DUG number 107, it was written as 111. Now, all through the proceedings, my lord, the petitioner was, my lord, your lordship will kindly see page 40. Others are there, I'm showing page 40. 48%, 48.
48.
Yes. This is by the Latmandal to circle officer. Last page, madam. Based on the field verification conducted in presence of the partners, their proportionate share of the land measuring 1 kata 13 lakhs of DUG number 107 under possession is shown below. Madam, petitioner's name is in page 49, Amrit Chandra Borak. It is in respect of 5.5 lakhs of land that will go for acquisition. And your lordship will kindly see page 40 now. This was because they could not finalize the land acquisition value. The matter was sent to the additional district judge, page 40, to the district and session judge under the NHA Act. And below, my lord, petitioner name is there, Amrit Chandra Bola.
Yes.
Now the learned additional district judge has passed an order at page 41 without hearing me.
Where is that? Page 40.
Page 41. I was not heard, others were heard.
Any appeal?
There is no provision for filing. This is an decision order without hearing me, without all throughout the proceedings, I was heard. So therefore, the compensation amount, my lord, determined in respect of.
Why were you not heard? You not made a party.
What, but others were hurt. I was not hurt, my lord. I didn't even know. Your lordship will tell that page 40 matter referred to the district judge because they could not determine the compensation. So district judge, my lord, while writing the concerned parties.
But did you receive any notice?
No, we did not receive any.
Mr. Hendrik, you'll have to update it.
Lordship.
Hello.
Two and three, Lordship.
Is that is the owner of 5.5 the church. Okay.
That number 107.
Where are the particulars?
Particulars I'll give you.
Page number?
I'll provide.
Page 24.
Page
24.
24.
The schedule of the land, my lord, sale deed.
That is the sale deed, but here Doug number is wrongly written. Instead of 111.
That is your 111. That's why, my lord,
We are in possession of the land since 2001.
No. What is the schedule?
Schedule is this, but it is in respect of Doug number 107.
Land was, my lord, acquired.
According to the petitioner, it's covered by tag number 107.
Yes.
Of periodic patta?
Periodic patta 112, Lord.
112.
Your lordship will get it at page 48. Period patta number 112 located at Sangli village has been acquired for 4-lane width.
Periodic patta 112 at located at Chengeli village.
Yes.
Which was acquired for 4-lane for the construction of 4-lane national highway. So the petitioner, along with other co-parties, were required to be paid the compensation. However, the compensation will be determined and record. The district judge Jorhat under the provisions of the National Highway Act. The district judge, additional district judge Jorhat, by order dated 28th of March 2024 in land acquisition reference 30 of 2022 decided the matter. However, the petitioner, although was served notice, not heard in the matter. The review is the process court. The third learned counsel for the party did this 4 weeks. Mr. J. Henry get you on behalf of the respondent number
2 and 3.
Since the respondents are permitted to complete their assignment, notice on any interim prayers.
The compensation should not be disbursed in respect to the petitioner, in respect of the 5.5 acres of land.
Notice on the interim prayer. The competent authority did not disburse compensation in respect of 5.5 acres of land covered by so and so tag number, pattern number.
Covered by tag number 107, periodic pattern number 1.
According to the petition, belongs and is under his possession. So, that will be declared on 2nd of August.
Obliged.
Yes, Lord. Lordship, my younger sister was killed, my lord, by her in-laws. And to that effect, my lord, I have lodged an FIR before the officer in charge of Bhagwan Police Station on 16/5/2024. But that was not registered, my lord. And thereafter, my lord, I have filed a complaint before the SP Valpara, my lord, case 13. Kindly see, my lord.
Still not registered.
It's still not registered.
Yes, have it obtained in practice.
Lord,
M. Al.
Station, Bhagwan Police
Bhagwan.
Station, the district of
Valpara.
Valpara.
Yes. Why? If I not if registered officer. If the copy be furnished by tomorrow and to be listed immediately after the date.
My lord, may I fix it? Lordship may fix it.
19.
9. Highly open.
May please, my lord. My lord, may I pray for the time being, Mr. Dekai is on like.
Time being, not possible.
My lord, in that case, the item pertains to payment of compensation for acquisition of land. The petitioners herein are the owners of various tea estates. They've been mentioned therein.
What are your prayers?
Prayer, my lord, is that the limited prayer is that the compensation which was fixed earlier by the respondent authorities, it was unilaterally reduced later on. We just pay that the original price which was fixed, that may be paid to us.
Okay.
3 to 6, Lord.
Sorry. One. The uh,
27.
27 July.
within a period of 1 week.
Very well, my lord. Wonderful.
The matter be again on 29th of July.
Deeply obliged, my lord.
Extra copy detail. Can you do notice?
Yes.
May I please, your lordship? My lord, basically, we are challenging a notice, my lord, with page 60. This is a, my lord, order of demarcation of land, which is, my lord, in violation of the office memorandum and the guideline, my lord, which is required to be go for the demarcation of land issues, my lord.
Where is the GMC count?
My lord, his name has been shown, and Mr. I have also informed Mr. S. Bora, my lord. He is supposed to appear.
Done. Okay. Yes.
As per number 2 and 4, Doctor.
The case for GMC.
S. Bora. Is the improvement. 60.
Is only
Only, my lord, that
asking you to
loss is appearing.
No, my lord, that is the discrepancies in my lord. I have also annexed the office memorandum. If a citizen is agreed with the my lord, or if he want a demarcation of a land, then my lord, the procedure has been prescribed under this office memorandum. My lord, may kindly have a look, my lord. That page.
No, we are keeping your interim order open,
My lord.
but stay this process.
My lord, because if this process is allowed to proceed, my lord, then it will be in violation of the law.
Why?
Because my lord, law says that the report of the Mandal, report of the Kanungo is required before proceeding with the demarcation. Without following that.
My lord, that is there, Lordship.
Available.
No, that is not available, my lord. I have annexed all the, my lord, from the initiation of the proceeding till the last notice, my lord. My lord.
From this notice, it is not possible to say that, let us assume that the report of the Mondal and the Kanungo is necessary.
My lord.
How that report will be obtained? By actual field verification.
No, my
For
lord,
which
before,
it
yes,
has
my
to
lord,
be done in the presence of the parties.
that is the issue, my lord. But that without obtaining that report, now they are directly going for the demarcation.
No, Lordship, kindly
That
see
is
the
the
page,
issue.
page 54, Lordship.
Yes, my lord, this is the order sheet where from the proceeding has been initiated.
Proceeding has been initiated, my lord, that
Connected
in every
seven.
time, my lord, that other person was absent, Lordship.
No, no, but we are not absent, my lord. It is.
It is written in the, my lord, the order sheet, Lordship.
Expertly order, my lord.
Page 54, Lordship.
They have refused to accept notice.
My lord, even the notice has not been furnished to us, only the last notice by which they have. My lord may issue notice on the interim on the returnable date, my lord may consider.
We consider that.
My lord.
Heard.
My lord.
Issue. Of the fixed on 19th of July. Prayer for interim should be considered of the return.
My lord. Obliged.
Yes, Mr. Bora, we have noticed.
Lordship, I appear for TN.
James.
Make the Lordship. Lordship, this is the matter pertaining to salaries earned.
What happened?
Lordship, Lordship, the appeal has been committed to face this mode, Lordship. So date cannot be ascertained by the hearing Guwahati law. This is my
It's more only has to be done by some.
Yes.
Is it done by AI?
Lordship, regarding and what is the status that it cannot be ascertained unless we obtain instruction from the CTB.
Unless
We have to obtain instruction from the board law. This is my instruction.
what are your prayers here?
Lordship, no coercive action till the appeal is disposed of. Because July I have to file, there's a demand on me, which is palpably wrong. But because of the appeal pending, when I file again July, they could attach, they could do anything. So pending disposal, no coercive step.
But there must be a, where is that demand notice?
Lordship, the demand notice, there is, Lordship, we find out from a portal, Lordship, page 37 is my original return for assessment year 2010, 2011.
No, you said that there is.
And then I get to know from a portal, Your Lordship, when I ask for a refund.
Where is that?
They have, Lordship, that is at page 71. Lordship, that is another ground of challenge. They should have this first 2010, 2011.
Now you are concerned that the appeal which is pending is not been disposed of.
Lordship. And what
They
will
are
happen?
unable to give us a date when, what is the status?
Yes, and I filed in November last year.
Third turn. Yeah, she responded.
Lordship.
In a period of one. Submitted by government. An appeal is referred to the appeal. Is there any indication of the appeal number or anything like that?
Lordship, appeal is page 90.
9.
Yes. There's a notice communication reference ID.
Okay.
Lordship, 91. Lordship, 91, sorry. 91. Apologies, 91.
Appeal has been filed on 6th of November. And appeal date order is passed. SSC has the notice, you are preparing appeal against which order?
Lordship, that's at page 87. Where they treat my email as a rectification application and says no paragraph 5.
This appeal is directed against the order dated 30/10
Yes, sir.
and by rectification. Read more, section 155. Was respect of till income. Amount fact, the amount of 16 lakh,
16.6. Round up.
16 lakh, 60,000,
110.
which according to the is not the minimum that is acceptable. Sorry, it's
not
tax free. And not the response. Even adverse order is passed. So far as the demand, but right. I think till the next date, 29
Yes.
of July.
Yes.
Yeah, please, Lordship. This is relating to time barred Lordship assessment. Lordship, my even though the time barred assessments have been stayed in on the ground of force measure, my ground is a bit different, Lordship. That is why, Lordship, I'm before you, Lordship. Lordship, page 12 is the Lordship section 168A, on the basis of which all the notifications has been issued.
Page?
Page 12
12.
of my writ petition, Lordship. Lordship, may kindly see section 168A. Lordship, section 168A puts up two Lordship precondition. First is, notwithstanding anything contained in this act, government may, on recommendation of the council, by notification extend the time limit which cannot be completed or coupled with due to force majeure. So my first condition is recommendation of council. Second is force majeure, Lordship. So, Lordship, I am harping on the point of Lordship recommended. There was no recommendation of the council when this order was passed. Lordship, my order is passed on 30/4/2024.
No, recommendation is for extension.
Recommendation is not for extension, Lordship. Even if you extension of the timelines.
That's right.
Yes, Your Lordship. This 56/2023, which has been issued, extending the timelines. Apart from being force majeure clause, it should satisfy that there is a recommendation of council and then only they can issue this notification. 56/23.
Seem to be.
Lordship, it doesn't seem to be. Lordship, I'll place the recommendation of the GST council. Yes, Lordship. The copies of the recommendation of the GST council.
Recommendation is just come now. We are referring to the recommendation.
Lordship, this is the 49th, not 53rd.
Huh?
This is the 49th, not 53rd. It was issued on the basis of 49th recommendation.
You bring it on record. Why are you?
Lordship, I have got it on record also, Lordship. It is there at page, Lordship, 82.
80?
Yes, Your Lordship.
Yeah.
Lordship, the relevant portion is at page 84. This is the entire minute, Lordship. This is the extract.
What?
Lordship, page 84, Lordship, agenda from.
Extension of time limit.
Yes, Your Lordship. Extension of time limit. So under section 73(10) of CGST Act for the financial year 17/18, 18/19 and 19/20. So, Lordship, this Lordship was allowed this extension of time limit. This was taken on 18th of February, Lordship, 2023. Lordship, there was objections from all the secretaries and all the members of the committee. The secretary, Lordship, may kindly see 5.7.1. The secretary stated that law committee has recommended the extension of time limit for issuance of SCN orders. However, the time period for issuance of notices and passing for these financial years has already been extended considerably due to extension of due dates of filing returns for the financial years. Further, the financial year 2017-18, the date of passing order has also already been extended till September 2023. So this lordship was recommendation was made before 56/2023. It has been proposed to be extended further from September to December. We mentioned that while the request of some tax administration was to extend the time limit for a longer period, or keeping the taxpayers' interest, law committee has recommended an extension of only 3 months for these financial years. Since all the states have agreed, the said time limits could be extended. Honorable member from Bihar stated that while this proposal could be considered, however, it should be decided that such an extended time limits for this financial years under subsection 7310 is being made for the last time. This was the last 3 months extension which was provided.
3 months from which date?
3 months lordship from lordship the 2018-19 was December lordship. Last date was December. They could have extended for 3 months only till the month of March 2024.
In your case, what was the order passed?
34/2024.
Further extension.
Further 1 month extra extension has been provided by 56/2023. So recommendation of the council lordship, they have gone beyond the recommendation of council.
Yes,
Notifications have been issued by the central government, my lord, by CGST.
Meeting.
Yes.
And accepted extension
Only for 3 months. Last time.
3 months.
For the last time.
It expired.
March.
2020. Further extension of time. Further time. By S. 3.
34/20.
Where is that section?
Section 73. Lordship.
Page number?
Lordship, page 110.
You are referring to the provision of which section?
Lordship, I am just, this is the order, Lordship, which has been passed. Section 73, Lordship.
Page 12,
168. 168 is quoted at page number 12, Lordship, and 73.
Where is the order?
Lordship, the order is at page 110.
I think that in 1 week. Extra copy. For election. 26.
22nd, I will not be there. Any other date?
Let it come on the day.
Let it come. Something
Let's-
will be there. All the other matters are fixed on 22nd.
Lordship, 16 is also similar, Lordship, that which I had Item number 16, time being was there.
Why was it kept time?
Lordship, I was waiting for one instruction, Lordship. Lordship, in this case, Lordship, one extra point which I have taken is that the state has not issued the notification which has been issued by the center. The state has not accepted it by issuing a separate notification, because state of Assam has to issue a separate notification in that.
But it is recommended by the
Yes.
GST council.
Yes, sir, Lordship.
If the state is a member of the GST council.
Lordship, but Lordship, in their state act, Lordship, what they have done is that section 11(4), they have restricted themselves to only those notification. In section 11(4).
So you urge this at the time of hearing.
Lordship, then in that case, Lordship, only force major point and responsibility.
Aye. Yes.
Much of.
No, the extra copies may be served by tomorrow itself. By tomorrow itself, otherwise, my lord, because of vacation.
Extra copies be served within working day.
Yes.
My lord.
Yes.
Yeah. Once again, my lord, we are not challenging the auction here by the PF authority. We are only saying, you know, let the PF, if it manages to sell the tea estates, let the PF appropriate its share. My lord. The balance sale proceeds should not be disbursement, because, you know, for the loan accounts have turned NPA, and we have initiated SARFAESI Act proceedings.
No, but what you have already initiated at the surface.
Yes, but my lord, the property, if it is auction, then nothing remains, my lord. This is the principle of the substituted security will apply here. I have a right to this sale proceeds. PF, my lord, we are not trying to call the auction. Let the
PF authority.
Lordship, I'm appearing to respondent 2 and 4. But Lordship, the prayer is not really against us.
Yes, we are not challenging the auction, sir. We are only saying that the sale proceeds apart from the PF.
2 and 4.
So 4 and, sorry, Lordship, 4 and 6. 4 and 6.
2 is my lord.
Yes, Lordship. Apologies. 4 and 6.
4 and 6.
Yeah.
Who I am appearing?
So who's put it to auction?
Lordship, we have.
Yeah.
Under the Act, we cover PF rules. And Lordship, the prayer, if you read on page 23, the problem is after we deduct our dues, the balance, how it's to be distributed. So it's not really, he's not disputing
We are not
the
disputing that.
option nor our right of first charge on the amount. Lordship, page 23.
Yes.
A writ of or in the nature of.
This is being auctioned, keeping in view the dues of the
Yes.
only.
Yes, PF. My lord, the total
What makes you
outstanding,
think that there will be some balance amount?
because my lord, the reserve price, if combined of both the tea estates, comes to 8 crore 10 lakhs, and their dues is less than 2 crores.
There will be a balance amount.
But once the tea estates are sold, then my lord, nothing remains.
But that depends on what we get. Last time we didn't even get anything.
Provided, of course.
Where is that auction?
Now, the auction notice, my lord, is at page 191.
Yes.
Well, I appear for respondent number 2. So for this, my lord, the prayer made in the writ petition are concerned, my lord, I'll have to seek inspection. But my prayer will be, my lord, let this particular process please, my lord, continue. And my lord, subject to outcome, which may be kept.
Yes, because the auctions are stated are supposed to be held on 8th
At
and
this stage,
9th.
at least.
My lord, let
And
the
Lordship
auctions
will post
proceed.
it immediately after vacation. my lord.
Lordship.
On 17th.
Heard that. Right. Great. Auction. File the petition. All file the respondent number
4 and 6.
4 and 6. In respect of the which tea garden?
My lord, in item 48 is Deepling, my lord, and 49 is Rajabhat.
Respect of the have recovered
Surface.
has own of date of my there over petitioners are also have claimed security. What is being secured? What is being offered as a security? Or as
Mortgage.
The leasehold right over 30-year lease period over both the estates.
I mean, for the loan which they have availed of.
Look, the lessee, my lords, of the ATCL, as the respondent number 2, my lords, had created the lease, my lord, and that he was granted the lease, and that was the mortgage with the bank.
Yes.
Lease for?
Lease for a 30-year period for the entire tea estate.
So the leasehold right.
Leasehold rights.
Leasehold rights,
By the respondent 7.
No, the respondent number 7 is the leaseholder, the lessee. We have to say the secured creditor.
Respondent 7 is the director.
No, he's he is the lessee. He was granted the 30-year lease.
ATC actually auctioned them and respondent 7 came in.
But they
and purchased.
prayer of the written that one amount within the price by forensic balance of due on account the amount of
2 crore. Without
approximately 2 crore.
1.5
where
in
do you find it?
No, that is there in the auction notice
No,
itself.
Where is
one-
that?
Page 191. This part, whereas the then authorized officer, she so and so has forwarded.
191.
Yes, sir.
Wait, la-
1,63,97,648. That
153.
Lordship will find it that this partner, whereas the then
153,978. Given by the third regard. That balance. If it
No, final offer,
Regarding Rajabari, it's about 48 lakh. You'll find it the other end. Page 179.
which item number?
what I pray is, my lord,
This is
that
48.
yes, but the lease auction should not be finalized, my lord. So the auction proceeding should not be finalized. That's my prayer.
Why?
Because my lord will have to, my lord, finally, whether the petitioner will have the right to have a claim on the, my lord, auction per se, auction sale. That will have to be decided by honorable court.
That is
Not that, my lord,
that will be decided subject to the
let
auction.
them proceed. I'm not saying, my lord. Let them proceed. Immediately on the reopening.
What is the progress of your proceeding?
We have issued the demand notice under 13.2 that we have annexed in the because the accounts have turned NPA just on 29th of May month. In the previous round when we came along, the accounts were not NPA.
We have to see the interest of the ATC too, my lord. So let the notice go, my lord. Should not be finalized, my lord, till the next.
No, Lord, what should not be finalized? My lord, my learned friend submission is a contradictory submission. Auction should proceed. We are not
Yes,
opposing
of course, my lord. Auction should
We are
proceed,
saying
but
let
it
the
should not be
PF take
finalized.
the share, my lord, because it's a social
My lord,
security.
he cannot, my lord, say that whether who get the share now, my
No,
lord.
I'm
Today
clear.
itself, my lord.
No. His prayer is that only to the extent of
Balance.
Balance proceed. The balance of the sale proceeds.
the auction should be permitted to be held.
My lord.
Whatever excess amount not be
Yes.
Correct.
That is the limited
That is
prayer.
the fight about the balance amount. Who should get what? After we get,
provided you get.
provided.
Correct.
Yes, Your Lordship. We didn't get it last time, so.
Can it be on 17? At least whatever is the status that will be placed before the announcement.
17th.
On 17, madam, 17/7.
On 17th, then from 17th.
Yes, instead of 4, it should be on 17.
Lordship, same order in 49.
Where is the notice here?
Lordship, page 179.
Right? Bring a sum of 7.1. The price
2 crore 10 lakh.
wholesale.
This is Rajabari piece.
The other one?
Deepling.
Deepling.
Look at one place, I believe Lordships have said,
Yes.
in the dictation, I think one place initially Lordships have said petitioners have availed, petitioners have granted the loan facility. That we can-
Obliged.
This case concerns the registration of the Bharat Stage 4 vehicle.
Your Lordship, we have filed our affidavit in opposition, but it's not yet on record.
Not on record.
We have filed on 25.
Submitted by the respondent that the affidavit has been filed. The speech already appears. Has been a speech. Yes, of the affidavit has been filed. Which respondent?
Respondent 5. Lordship has-
Yeah.
Which department?
Transport Department.
Transport Department. And immediately after. Petitioner in the meantime may file with order.
Lordship, they have admitted the position that all 60.
Given you liberty.
Yes.
You want.
Yes. Great.
May I please, Your Lordship?
Yes.
Lordship, petitioner's husband was died on 24/8/2023, my lord. And thereafter, my lord, one legal notice was served on the petitioner, my lord, on 1/2/2024, and by which, my lord, it was stated that petitioner's husband took one loan, my lord, 7 lakhs amounting, my lord. And thereafter, my lord, very surprisingly, my lord, the petitioner's salary account was held, my lord, by the bank without any legal authority, my lord. And thereafter, my lord, Lordship may kindly see the, we have lost one complaint, my lord, before them. Then page 22 is the reply, my lord. Page 22.
You've been asked to visit the branch.
That is totally false, my lord.
Huh?
That is not correct, my
No,
lord.
no, in the letter it is written. Last page, page 23.
My lord.
Page 23.
That is false, my lord.
False means
False means they never approached before me, before
by
this.
the letter they are asking you to visit.
Yes, my lord. But my case is, in this case, my lord, it is not a case that we are not ready to pay, my lord. We are trying to negotiate, my lord. But the main grievance is that salary account, my lord. They cannot hold my salary account, my lord. Because my, we are,
Whose salary?
my wife's salary account, my lord. Husband already died.
So your wife, your
Petitioner is the wife of the, that earlier, my lord.
You are also working somewhere.
Yes, my lord. I have annexed my identity card, my lord, page 15. I have 2 sons, my lord. See,
Are you a guarantor for that loan?
no, my lord.
Yes, Mr.
My lord, my instruction is that the account was put on hold, my lord, but subsequently it was withdrawn, my lord. That hold has been lifted, my lord. On 19/2/2024, his account was put on hold.
Whose account?
The petitioner's account, my lord. Then subsequently, my lord, on 28/2/2024, his hold was removed, my lord. And the petitioner has not cooperated with the bank regarding the settlement of her husband's account, my lord. My instruction is that we have removed the hold, my lord.
They have removed it.
My lord, she was trying, my lord, but could not operate his account, her account, my lord.
You
My lordship
get the
may
instruction.
fix the matter immediately after reopening, my lord.
Yes.
I'll take instruction, my lord.
Sir, as Dr. it is the SBI.
My lord.
That salary by the bank has not made for by it has been not yet. Not yet. So, that's salary. There are that usually the account, but the effect of
28 to 24.
24, that restriction was drawn. In other words, the account less also submit like this is the matter here on 22nd.
My lord. My
Okay.
lord.
Obliged.
Lordship, this is the appointment of substitute arbitrator, Lord. The section 1150.
Your affidavit,
Lordship, it is
Any
not
app-
come on record, Lordship.
Huh?
It is not come on record, Lordship.
why have you not brought on record? Have you filed it or not?
Yes, Lordship. Lordship will take an extra copy
Why should I take an extra?
tomorrow, Lordship.
It is for what?
For appointment of substitute arbitrator, Lordship.
What has happened to the origin?
Lordship, original, basically, the thing is that one colonel appointed for arbitrator, Lordship, but due to real health, he resigned it. Thereafter, one chief engineer appointed arbitrator. She has proceeded for 1 year, could not able to deliver award. Thereafter, both the party extended time to him. Even then, she is not able to deliver award. Then mandate was
What is
terminated,
the
Lordship.
stand of the respondent with respect to the prayer?
Lordship, in fact, the earlier arbitrator passed an award, but because of the order passed by this court, that will be nullified, Lordship. Because this court held that the extended period is beyond the permissible limit.
Award was interfered with.
No, not interfered with. It is kept in a sale cover because we have paid, but they have not paid. In any case, Lordship, because of the order passed by this court, that may be
What was the direction of the
Lordship, like this court has set aside
set aside that order by which the district just permitted to went beyond 6 months, Lordship.
this order, ordered by the earlier order has interfered with which judgment?
in judgment at page 6, Lordship.
Judgment at page 6.
Page 6, Lordship. CRP 13.
I know, but
The mandate has been terminated, Lordship. Of earlier.
wait, please read the operative part of the order.
Lordship, then I'm coming.
Page 10, Lordship.
Page 10, no, Lordship. I'll go to this. That is at page 15, Lordship, para 15. The impugned judgment dated 22/3/22, however, is completely contrary to the scheme as well as the provision of the Act of 1996 as discussed above, for which the impugned judgment and the order is set aside and quashed, leaving the parties therein to approach the appropriate forum in terms of Act 1996. It is further observed that the view of the setting aside of the judgment and the order dated 22/3/2022 passed in CS arbitration so 1/29, anything done by the arbitrator in the arbitration proceeding pursuant to the 4/8/29 would be without jurisdiction and authority of law. They have the arbitrator has passed the award, but it was not open. That was it is written. Anything done by earlier arbitrators is also set aside. Now, sir,
Where is that finding? Paragraph
Page 11.
11.
Page 11, Lordship. The ending part of paragraph 15.
So after expiry or prior to expiry, who approached the district judge?
He approached.
I approached the district judge for termination of mandate under section 14.
After expiry.
After expiry. But district judge two moto extended the time. Either the application from my side, that application, that judgment is set aside by this honorable court and allow us to go for arbitration, for substitute arbitration under 15(2).
What is your
Lordship, we have a panel, Lordship. From this, someone may be appended.
What do you think?
Lordship, my submission before is that, Lordship, they have, respondent had failed to appoint arbitrator when initially I approached to the chief engineer for appointment of arbitrator as per agreement. They failed within 30 days. Then I requested this honorable court appointed arbitrator, the colonel, that was one lady chief engineer. Then that was set aside. Then automatically I come for third arbitrator to decide the pending dispute under section 15, Lordship.
What happens to the award?
Award has been not closed, open, Lordship. That has been not opened because the High Court has terminated the proceeding of that. That was sealed cover is still there. That is of no value. It is mentioned in para 15 also, Lordship.
It was held to be without jurisdiction.
Lordship, in last para.
Let their affidavit be on record.
Lordship.
On record.
Lordship.
Can we have it immediately after reopening?
Lordship, on 17, my other cases there on that day.
And if it's like, and it is submitted that the respondent the file that take on record, verify and connect the affidavit. Is the matter on 17.
Lordship, oblige, oblige.
Lordship, this matter will be taken up after vacation. I have not received any instruction in this matter.
Lordship, give it up, keep the date on 25th July, and that should be the last. I think no further than 10th to be given.
Arbiter.
Sanjay Sharma.
Sanjay.
25 July. 25th.
Oblige.
Yes, what happened?
My lord, in this matter, my lord, I have received instruction yesterday, my lord. So, I'll file vacating, stay vacating application, my lord, for vacating the interim order. My lord, let it be fixed on 18 July, my lord.
You first file your application and then make a mention how it's a date without even filing it. You have not even
Next
filed.
day, my lord, next date may be fixed on 18 July. Before that, I will file that.
We posted after vacation.
Yes, my lord, after vacation on 18, my lord. On 18, my lord.
So what is the status now?
My lord, actually, the read petitioner was not in zone of consideration. We have
Was he
people-
allowed to participate? Not allowed.
He was allowed to participate.
However, his name was not considered, although he possessed all the qualification in regards to his promotion.
Then what remains is the read petition now? behalf, but you have the pretty to tell us your prayer was that you should be allowed to participate.
Yes, okay.
You are allowed to participate.
Yes, sir.
Now you are not selected, it becomes another cause of action.
But in regards to this matter, I am the senior most employee and
Therefore, after participation, result is declared, is it?
yes, however, that
You are not
against,
selected.
yes, I am not satisfied against the state order, and we have preferred this petition before this honorable court.
How? This writ petition is prior to the declaration of the result.
But in that regard, my senior may be come here. Let me be.
Where is your senior?
Due to some personal difficulties, he is not appearing today.
Just become interested. Why are they keep pending? Call him tomorrow.
Yes.
Let us hear tomorrow.
Yes. Deeply.
Public.
The last provision, my lord, Lordship has directed them to obtain the instruction whether, my lord, Assam Brick Establishment and Regulation Rules 2022 as gazetted notified.
Yes, any instruction?
My lord, copy of the regulation has been provided, my lord, but they are unable to take that whether it is notified under gazette notification or not. This is the notification. No, there is a clause regarding notification in gazette, my lord. That information they could not have, I could not obtain.
We just want to know whether it is right or not. Coming to effect of the date of their publication in the
Yes, my lord, that clause is there.
Who has prepared the rules?
This pollution control code.
No. You get it from the, I think the.
It is easily available in the Google.
Legislative department, I think they will have.
Right.
Right? MS folks. Right for further time. Okay. The Assam. Big bill happening. Right?
13.
My lord.
It's after
16th on 16th, my lord. On 16th of July, my lord.
16th of July.
My lord.
Right?
My lord, already, my lord, there are, my lord, so many raw materials are being damaged, my lord. Already
17th.
My lord.
Last to this is RTI matter.
Instruction to Mr.
Lordship, I have,
CS pension
I
is
have
applicable.
received the communication today from the matter.
During the course of hearing of this matter by your lordship, they want to pass order. This is what I find from the letter.
They have virtually admitted.
They virtually admitted, now they are saying we will pass order. Your lordship has heard the matter, completed the hearing. This they cannot do, my lord. They are sitting over your lordship.
All right, we'll pass order.
Right.
The matter.
Hello, only.
We are disposing it off. We are allowing the writ petition. In view of the fact that there is already a finding by the coordinate bench earlier. Single bench.
Admit,
And
virtually, my lord, it has been admitted that.
Admitted, and there is no appeal against those findings.
Matter.
So far as the writ appeal order is concerned, that of the facts perhaps is not applicable because he being a civil servant, he is governed by the PCS rule. And he completes his tenure of
In
10
that
years.
event, my lord, my alternative argument will be, my lord, that although it's 16.5 says that will be entitled to pay and other terms as that of the chief secretary, my lord.
But retirement benefit will not be there. That may not include that.
This is the problem here.
No, that's what your
That,
lordship may
that is
record.
that lordship may record it.
You want this, his submission to be recorded.
Let us try to do it tomorrow.
Tomorrow is the last day. Whether will it be possible?
It will be possible if you
I have no problem. I have no.
Let us try to do it tomorrow. Because I'd like to dictate it in court because it contains certain facts. That's the only thing which will be necessary.
Presence of the council will be.
Correct. Basically, great. As it has already happened in the case of the earlier order as well as the appeal order. In principle, there appears to be a conflict, but when you look at the facts, the single judge.
No, it is always better when in presence of the council.
Right.
We'll
We'll have it in the second half tomorrow.
Yes, 2 o'clock.
2 o'clock, 3 o'clock. It could be 6 o'clock.
Mood will be deemed tomorrow for everybody.
Or can it be, my lord, on the reopening day?
No, we have already heard this matter. By this communication, you have virtually admitted that yes, he satisfies this requirement.
They are probably, also say that they are re-examining.
How is there to re-examine? They have already passed the order.
I don't know.
You hear our order tomorrow. This
Obliged.
tomorrow. This is matter. Item number 36. For order. It is temporary.
May it please your lordship. Lordship, the respondent was directed to seek instructions as to what steps they have taken to return the land to me.
My lord, we are willing to execute the sale date. My lord, time frame may be set by your lordship.
You do it by 17th of July.
That would be a very short time frame, my lord.
My lord, mere execution of sale deed will not suffice. They will have to hand over possession to us.
My lord, the property that is in question and the case that was mentioned earlier, upon getting the certified copy, it has been found that the patta number is different in the case. And
Either you contest this matter or you accept that yes, we hand over the land or return the matter. If you are contesting that you are not legally obliged to hand over the land because of whatever reason, then we'll have to hear.
my lord, if there is an encroachment after handing over giving then the
We'll hear it, madam.
sale permission, then
Set for hearing on 18th of July.
Lordship, it may be kept as part heard, my lord. Your lordship has already heard this matter at length. It was on the verge of disposal.
It was on the verge of disposal subject to their
My lord,
agreement. But
they are changing their stand on every single
we are
occasion. In
not,
the affidavit, they
my
say
lord,
something, then they
then
come
my
out with
lord, my
something.
lord may then allow me to bring the case records through an affidavit. Then I'll bring the record before your lordship. It will be convenient for your lordship to pass on.
Lordship may keep it part heard, my lord.
My lord, because of the
My lord, my lord, it was already admitted by them that they are ready to execute a sale deed. They have filed an affidavit before this honorable court.
my lord, can it come slightly later on 28th? My lord, my lord. In this matter, my lord, I was supposed to inform the honorable court regarding their awareness regarding the award, my lord, in victim compensation scheme, my lord, under the victim compensation scheme. In my communication cell, that it is over phone, they have informed my lord. But no family member appeared and
Now
responded.
what has happened? The award is there.
Yes,
The award has been passed.
3 lakhs compensation has already been passed, my lord, but
Has it been paid? You received it?
no, my lord. Because of fund, my lord, it was not paid, but the award has already been
Now
in
what is to be done? What is the point in passing an award if you can't pay?
No, last occasion, my lord, as he was not aware, I have to inform the honorable court whether it was passed or not. So I have that instruction, my lord. So far as
Why was it communicated over phone? The addresses are available.
my,
And there is any
Who is
number,
communicated over phone?
yes, that is it.
it's a communication of secretary, my lord, as per this instruction.
You want to inquire or you want us to inquire? Why the secretary has called the
Huh.
uh,
Yes, my lord, I have already told them, my lord, whether why it is not as per
what is the
order of
procedure?
procedure, my lord. After award, they have to communicate it to the victim, my lord.
How?
Phone is not a proper mode in my humble submission, my lord.
Have you got a copy of the award?
No.
Over phone, they have stated that they have called them to have the copy, my lord, as there is a contact number is there, my lord, but nobody has approached, come to the authority. So, my lord, I will instruct them to give a,
Fine.
in the meantime, my lord, I will.
Any information has been received regarding
Lordship,
communication?
yesterday I have taken instruction from my client.
Nothing.
Nothing. And
But your prayer before the court is for
5 lakhs.
5 lakhs.
That's what they know.
whatever it may be. Now,
Lord.
is there any appellate forum?
You can file appeal before the state like the legal service under section 3.
Lordship, if petitioner award the award of this, then file.
Copy will be served within a week, my lord. I will.
Complete your copy. It is
Go and appear for the DLSA and take the award. That is why contact number is there.
submitted that part of that award by the DLS. There. That home that is final award, but copy of the order be served on the petitioner
Within a week, my lord.
within a 1 week. And petitioner to agree for the appeal has provided that.
Right.
Keep that.
Public. Number 2.
Here, we are on the number.
I plead the lordship. Lordship, the matter pertains to the non-refund of excess TDS deducted from account. Lordship, they filed the affidavit yesterday. What is the
Already on record, my lord. Yes, my lord. Yesterday we have filed our affidavit in opposition.
Lordship, they have admitted their whatever we have named in the writ petition, they have
The
admitted.
affidavit be
Lordship, lordship.
Well, let it be on record.
Lordship.
You can be proved.
submitted by Mr. Please. Please, okay. Right.
Of July, lordship. Obliged, lordship.
Obliged, no.
Take some time, lordship.
Was it heard at some time?
It was heard at some time. refund application was
Pick
rejected.
after you. This is for hearing.
Yes.
It can be the part two hearing.
It was in the part two hearing, 2017 matter. Although it's covered by your lordship's order, but slight difference in facts. So I need to place that. Lordship's order in Bartek matter.
It's on 23rd. Like. Okay.
Can I be parted one?
This certain